Day 8. I've learnt my lesson. Are we live?
Working.
It's only taken it to day 8,
10 days.
as they say. Welcome to day 8 of the inquiry into the proposal by Waits Development Limited for up to 140 dwellings, community buildings, and sports and leisure facilities on land at Stocks Farm, Bramley. Very quick reminder for me, because I think everyone's been with me for today, to mobile phones to be switched to silent, please, and fire alarm, if it goes, is the real thing. Just a quick update on where we're at, and then I'll hand over to the advocates. It's day 8, and we've heard evidence from both the council and the appellants on matters relating to landscape, urban design and heritage, and an overall summary from the planning witnesses too. We've had the opportunity for involvement from district and parish councillors, for which I'm very grateful, and as I've represented some of the case of the interested persons and put those questions to the parties as we've gone over the inquiry. We had the opportunity in glory, I would say, Mr. Banner, to visit the site yesterday, accompanied by a number of representatives of the main parties as well as the parish and councillors, and had a very good walk around the area. The sun was low in the sky when we were trying to take some of the views back, and I undertook the visit this morning, which I did, and took views from the northern side of the site, with the sun over to the east, so not directly into our eyes. So I hope, and I asked on site, and I hope with that I've captured all of the views that parties wished me to see. Before I hand over to the advocates for their closing statements, let me just review yesterday. I did get in that last document, didn't I, from the council, the countryside services calculations. So I don't think there's any outstanding documents, but obviously there was some debate to be had on condition, and I think the unilateral, we reached some wording, not entirely agreed, but left partly with me, that was the wording that was being taken away for completion of the unilateral for signing. Did we get anywhere on the condition?
We did. There's a revised form of words for condition 29B. I've been handed up. It's their copy. And I believe I fairly reflect the position by saying it's common ground that if you were to go with B, this should be the wording, albeit the council still wishes you to go with C.
Yes. I attempted to be as clear as I could on that. That I wasn't accepting that pushing to get revised wording meant that I was choosing B or the council was failing to.
So this is now the condition, that the form of condition that we advocate, and the council's view is to say if you go down our route, then this is the right wording, albeit they want to rule out temporary arrangements such as tankering. Thank you to Mr. Dawes for.
No, actually, it's not.
Thank you. I don't wish to. Well, falsely true. Thank you very much for your help with that. It's definitely an improvement on the wording.
It's certainly more comprehensive, and as I look at it now, it captures, I think, the concerns that there was, if you like, no barrier to the inventiveness of a temporary scheme that could come forward almost at the same time as you were hoping Thames Water would come through, which meant that the commitments that appellants had made, and I'm not doubting their future delivery of those commitments, but conditions have to be precise. The commitments they'd made to it being only a last resort and only for 50 weren't necessarily enshrined within that condition. Such truly, there shall be no occupation be offered to it. Yes, good. Thank you very much for that. Council are happy, just formalities. Happy as they can be with that. It's not 29B. Okay. Was there anything else outstanding from our discussions yesterday? I don't believe so. Good. Has anything else raised its head that I need to be aware of before I hand over? Closing statements?
Not from this side.
Good. We're still on time on the programme, which is good news. And thank you for the start this morning. I'll hand over to Ms Sargent if we've got closing statements for the council, please.
Thank you, sir. I'll just hand hard copies out.
Oh, thank you.
Thank you, sir. The council submissions deal with the following points in turn. First, the landscape character and visual effects of the scheme and its effect on the settlement pattern. That's reason for refusal 1 and your main issue 2. Secondly, the effect of the scheme on heritage assets. So that's reasons for refusal 2 and 3 being your main issue 3. Thirdly, briefly, the effect of the scheme on the capacity of existing sewage drainage systems. Reason for refusal 6 and main issue 4. Fourthly, the adequacy of the provision made for community and infrastructure contributions. Again, briefly, reason for refusal 7 and main issue 4 again. Then all of the other adverse effects of the scheme and the benefits of the scheme. First, the housing contribution and then the other benefits. And finally, the overall planning balance and the overall conclusions of the council. Dealing first with reason for refusal 1, landscape character, visual effects and the effect on the settlement pattern. I turn first to the baseline position. The site is bounded on 3 of its 4 sides by public rights of way, including the Bender Parkaway, which it is common ground is a very well used long distance path. Indeed, one of the public rights of way runs through the southern end of the site, and as Mr Smith acknowledged, his assertion that there's no recreational access to the site itself is inaccurate in this regard. It's also common ground that 5 of the important views that policy D1 of the neighbourhood plan, which is part of the statutory development plan, requires to be protected are views of the site. Those are views 1, 2, 5 and 6 and Vista 4A. Mr Smith's contention that only the very small part of the site that falls within the conservation area is of local authority value, with the rest of the site being community values, is unpersuasive. First, it's not a view that was shared by his colleague who prepared the LBIA that supported the application for planning permission for the scheme. They concluded that the value of the site increased at its southern edge adjacent to the conservation area. Secondly, there's no acknowledgement within Mr Smith's analysis that the conservation area has a setting to its north, within which at least part of the site falls, nor of the possibility that the conservation area's setting might contribute to its cultural heritage interest, and indeed its common ground between the main parties, that it does so contribute. There's similarly no acknowledgement that Stocks Farmhouse falls outside of the conservation area, nor of the fact that part of the site falls within the setting of the farmhouse. Mr Smith's initial response to this line of questioning and cross-examination was to say that he was not considering the setting of heritage assets. Fourthly, Mr Smith agreed in cross-examination that the sole reason that he had elevated the conservation area itself from community to local authority value was because of its cultural heritage interest. There's no justification for elevating the conservation area itself in that manner without doing the same for the setting of the conservation area and for the settings of the church, Stocks Farmhouse and Middle Farmhouse. Mr Smith didn't provide any such justification. As he acknowledged, statute, namely the section 66(1) of the Listed Buildings Act, treats the setting of listed buildings as being of equal importance to both listed buildings themselves and to conservation areas. Listed buildings are also, as Mr Smith also recognised, listed at the national level, unlike conservation areas, which are usually designated by local planning authorities. Finally, the NPPF makes clear that both conservation areas and listed buildings might derive some of their heritage significance from their setting. The appellant's position is that the HDA landscape sensitivity study is something that should be given real weight in this appeal. There's no suggestion in that document that some parts of the site are of a higher landscape value than others. The site scores 4 out of 5 for historic value, and the site, which Mr Smith agreed is a reference to the whole site, is identified as forming the undeveloped landscape setting to the adjacent conservation area to the south and the wider setting to listed buildings along the street. Mr. Smith accepted that there's no suggestion in the LSS that only the southern edge of the site has any historical value. Dr. Hickey is plainly correct to conclude that the entire site is of local authority value. The apparent suggestion in cross-examination of Dr. Hickey that it was immaterial whether the value of the site was community or local authority, because it's common ground that the site is not a valued landscape for the purpose of paragraph 174A of the NPPF, was, as Mr. Smith agreed, a wrong one. On Mr. Smith's own methodology, a higher value results in a higher sensitivity, and a higher sensitivity potentially results in a different ultimate conclusion on the overall landscape effect. Dr. Hickey is not at odds with HDA as regards the baseline position. HDA assessed the entire site as having medium landscape sensitivity. Such a site is one that may be able to accommodate the relevant type of development in limited situations without significant character change or adverse effects, where such locations are defined in the relevant site summary. No such locations are defined for the site. Mr. Smith accepted this, and he also accepted that the LSS does not identify capacity to accommodate development on the site. Contrast the position of the Station Road site, which has a lower total guide score than the appeal site, and in respect of which the LSS expressly notes that the site has some potential for development, provided proposals do not adversely affect the setting to the conservation area and local green space to the south, and retain hedges and trees of good quality. HDA's view is thus that the site cannot accommodate the relevant type of development without significant character change or adverse effects. That is in line with Dr. Hickey's assessment. The appellant points out that the LSS assumed 60% built form and 40% open space, whereas the scheme proposes 76% open space. There is, however, no evidence that the LSS assumed that the open space would include allotments, a skate park and/or a bowling green. Turning to the landscape character effects of the site, the site lies within the North Sherman character area, and the landscape character assessment describes that area as a patchwork of mixed farmland and woodland. One of the key issues identified in the LCA is pressure for housing development, including extensions to existing urban edges, such as Chinham, Tadley and Bramley, encroaching into the character area. Under the heading Guidance, the LCA identifies that the strategic aim for the North Sherborne character area is to conserve the overall rural pattern of farmland and woodland with small-scale settlement, whilst limiting increases in urbanisation through incongruous development. The scheme does not accord with the strategic aim for the North Sherborne character area. As a result of the loss of farmland that it would entail, it conflicts with it. In response to this point, Mr. Smith initially referred to the proposed open space, but he then acknowledged that there is a difference in landscape character terms between that open space and farmland. His eventual response was that, on the one hand, losing farmland arable fields will have a negative effect on the landscape, but because the field pattern would remain, the position was, in his view, satisfactory. That is no answer to the point. The strategic aim is concerned with the overall rural pattern of farmland and woodland across the character area, not within the site itself. There's nothing in the apparent suggestion that Dr. Hickey's assessment of landscape character effects is insufficiently nuanced. Mr. Smith acknowledged that he had assessed some aspects on a whole site basis, and he also agreed that one could reach a conclusion of large magnitude in relation to the medium-scale fields becoming smaller scale to the south entry within his table D3, and that the same adjustment to the next row on form and colour would be an equally valid way of undertaking the assessment. In the Council's submission, that approach would more accurately reflect the reality of the situation, which is that there will no longer be any fields in the part of the site that will be occupied by built form. Dr. Hickey is right to contend that the geographical extent of the scheme's landscape character effects ought to be identified as at least medium, being landscape change beyond the site boundaries. The site would, as he observed, have a localised urbanising influence on the landscape character of the land surrounding the site. Turning to visual effects, sir, you'll have understood those with the benefit of yesterday's site visit. And the Council's position is that as regards the 9 key locations, viewpoints A to I, identified by Dr. Hickey, Even at year 15, the significance of the adverse effect will be medium high at 5 of them, high at 2 of them, and very high at 1 of them, with only one viewpoint experiencing a medium significance of effect. The adverse effect on the important views protected by the neighbourhood plan will be medium high in relation to view 2, high in relation to view 1 and Vista 4A, and very high in relation to views 5 and 6. Even on the appellant's own evidence, at year 15 there will still be a major moderate adverse effect at Mr. Smith's viewpoint 3, with moderate minor effects at his viewpoint 6, 7, 10, 11, 12 and 13. That equates to a major moderate adverse effect at year 15 on neighbourhood plan important view 6, moderate and minor adverse effects again at year 15 on views 1, 2 and Vista 4A, and a minor adverse effect in year 15 at view 5. Mr. Smith's contention that the scheme will protect, complement or enhance the important views is simply not realistic in the face of his own assessment. He relies at paragraph 254 of his proof on the fact that, in his view, all of these existing views contain glimpses of the existing settlement edge, and in some cases there are also clear views of existing pylons. Hardly any houses are visible in his photo montages, however. He conceded that there aren't a lot, and he accepts that pylons occur in rural landscapes. Mr. Smith's assertion that in every case the proposed design respects the neighbourhood plan view or vista by placing a greenway or open space in the foreground of the view, thus retaining an open prospect, is an exaggeration of the position. He conceded that a significant part of his viewpoint 3 would have built form in the foreground. Mr. Smith's insistence that even where the scheme would have a major moderate adverse visual effect on a neighbourhood plan important view at year 15, the scheme would still both respect and complement that view flies in the face of the wording of neighbourhood plan policy D1 and was entirely unpersuasive. The appellant's nuclear power station point does not withstand scrutiny. Mr. Smith agreed that Dr. Hickey had followed a methodology under which inputs relating to change magnitude and sensitivity produce a result in terms of overall significance of the visual effect. Mr. Smith's own assessment employs a similar methodology. For each contributing element, magnitude, sensitivity, etc., a threshold is specified in order to attain a categorization, such as medium, high. If a visual effect is sufficiently material that it attains the threshold that combine to give a very high result for the overall significance of the effect, that is the position. And the fact that a different scheme might surmount those thresholds with room to spare is neither here nor there. Neither methodology, Dr. Hickey's or Mr. Smith's, falls to be applied or indeed even sense-checked by first conjuring up the most adverse scheme conceivable for the site in question, and then reaching a conclusion on what proportion of the visual harm for that hypothetical scheme would be matched by the proposed scheme. Next, it should be noted that Mr. Smith's analysis excludes as not significant any visual effect that is not of at least major moderate significance, including therefore all moderate adverse visual effects. The Council accepts that where to place the threshold for a significant effect is not dictated by Glivia 3 nor anywhere else. However, the result of Mr. Smith's approach is that he's able to describe even the adverse visual effect that is discussed at paragraph 238 of his proof, which is his viewpoint 3, as only marginally significant, a description that in the Council submission does not reflect the reality of the position. I come next to the effect of the scheme on the settlement pattern of Bramley. Mr. Smith's calculation that the scheme would add around 3% to the total number of homes in Bramley appears to be wrong, but in any event, as he agreed, in considering whether the scale of a development is appropriate, one does not simply calculate what the percentage increase in the number of houses in the settlement would be. Furthermore, the only recently consented scheme in Bramley that Mr. Burton identifies as being larger than the appeal scheme is St James Park at 200 units. Portland Drive at 65 units is not quite half of the 140 units proposed for the site. Mr. Burton agreed that 140 units could not be said to be typical for Bramley. Mr. Burton also agreed that the Council, taking its internal officers and the independent witnesses fielded at this inquiry, did have the necessary expertise to assess the scheme's effect on the settlement of Bramley. Mr. Dawes is correct to conclude that the scheme would be totally out of kilter with the current village pattern. Whilst Mr. Burton contends that Bramley's settlement pattern cannot be said to be perceived as linear, the observation of Mr. Dawes that the existing development along the street and Minchin's Lane has developed over time as a linear form of development following existing road networks and field edges is supported by the LSS, which identifies that the development of the site would be inconsistent with both the general pattern of the settlement and with the existing pattern of ribbon development along the street. The description of the scheme and the first reason for refusal as an atypical extension is accurate. Mr. Burton's figure 5.1 shows a settlement depth across the site of 570 metres. That depth is not typical of Bramley. It is the second greatest depth shown in his figure 5.1 and by some margin. Mr. Burton conceded that 570 metres is not typical of the settlement depth along the street. See his figure 312, which shows an existing settlement depth in that part of Bramley of between 153 metres and 374 metres. Mr. Burton agreed that it was necessary to consider the character of the part of a settlement that a site is situated in. Mr. Dawes is also correct to observe that the existing transition between the village and rural countryside is intimate, subtle, and developed over many years, and that it blended with the landscape. As he notes, that can be observed by looking across the site from the Brenda Park away. Mr. Burton's assertion that the council has significantly underrepresented the positive placemaking aspects of the appeal scheme and has disregarded the numerous positive placemaking features is unjustified and is, in truth, entirely unfair. The council has not disregarded anything. The detailed design of the scheme is a matter for consideration at reserved matters stage, not at this inquiry. Mr. Burton conceded that the council was entitled to wait until reserved matters stage before assessing whether the design of the scheme was appropriate. Finally, in respect of the first reason for refusal, whilst Mr. Smith refers in his written evidence to a number of other schemes that have received planning permission, he acknowledged that you, sir, do not have the full picture in front of you in terms of how and why the overall planning balance was struck in favour of those other schemes. Station Road is in Oakley, not Bramley, therefore policy D1 of the Bramley neighbourhood plan didn't apply. The site is described in the appeal decision as being not very visible from two public rights of way, with only glimpses of part of the site available from a third. The Station Road site fell within the setting of only one designated heritage asset, a conservation area. Paragraph 202 of the MPPF was passed, such that paragraph 11D1 of the MPPF did not operate to prevent the scheme from being granted planning permission. The Station Road inspector found that by year 15 there would be no effect greater than moderate in terms of any visual or landscape receptor, an outcome that the scheme here will not achieve, even on the appellant's own evidence, as Mr. Smith accepted. In relation to St. James's Park, the site was of an enclosed nature, which, as Dr. Hickey explained, isn't the case here, and a balance was struck between the impact on landscape character and scenic quality and housing delivery. The quantum of housing was 200 units, which Mr. Smith agreed was significantly higher than the quantum proposed in the scheme. The council's planning officer did not consider that there would be any harm to the heritage significance of the church. And finally, as to Clift surgery, Mr. Smith conceded that that scheme was not remotely comparable in scale to the appeal scheme here. I turn next to reasons for refusal 2 and 3 and the effect of the scheme on heritage assets. It's common ground that the scheme would harm the heritage significance of several designated heritage assets. The NPPF is clear that all heritage assets are an irreplaceable resource. Any harm to their significance, including from development within their settings, requires clear and convincing justification. In addition to Dr. Hickey and Stoughton, the extent to which the scheme would harm the heritage significance of heritage assets and how that harm should be categorised for the purpose of applying the heritage policies of the NPPF has additionally been considered by Historic England's Inspector Ms Ryan twice and by the Council's Senior Conservation Officer Mr Eyre. Their respective positions are as follows, and so I won't read that table. The weight that should be given to Historic England's views is addressed below. The salient points from Ms Ryan's consultation responses can be summarised as follows. For the council submission, it's important to note that Ms Ryan's analysis remained the same even after she was provided with the environmental statement chapter on heritage and with an updated built heritage statement between her initial 8th of March response and her later 21st of April consultation response. Historic England's view overall is that the scheme would cause harm to the significance of the church, stocks, farmhouse and the conservation area because it would remove much of the wider rural setting to the listed buildings and conservation area and would reduce, there's a typo there I think, our appreciation possibly, but so you can check for yourself against the letter, of Bramley as historically a small rural village with strong agricultural ties. Bramley is noted as a small rural village and the conservation area as being bounded by fields, showing the important relationship between the village, the farms and the wider landscape. The rural setting is stated to be an important part of the significance of the conservation area, enhancing the character of this attractive historic village, which is unusual as it has not been surrounded by modern development. As regards the church, Historic England notes that views of the tower from the north currently place the building in an attractive rural landscape, which enhances the aesthetic value of the building. The historical associations between Stocks Farm and the site are noted. Ms Ryan explains that Historic England thinks that the impacts are greatest to Stocks Farm, the church and the conservation area, and that as such her letter will focus on those assets. It's not possible to know whether Ms Ryan's view is that there would be no harm to the significance of Middle Farmhouse, or whether that asset is omitted from her analysis because she took the view that the impacts would be less significant than those to Stocks Farmhouse, the church and the conservation area. Before turning to consider the individual heritage assets in turn, the Council makes the following observations. First, of all the parties who have considered the harm that the scheme would cause to heritage significance from the perspective of the NPPF, Ms Stoughton is the only one to conclude that there would be no harm at all to the significance of the church. Dr Hickey's assessment of harm to the significance of the church, as lying at the middle of the range of less than substantial harm, accords with Historic England's assessment. Mr Eyre considers that the level of harm caused would be higher at the upper end of the range. Thirdly, there's no disagreement between Dr Hickey and Ms Stoughton as to the level of harm that the scheme would cause to the conservation area or to the non-designated heritage assets. In relation to both the conservation area and the non-designated heritage assets, Dr Hickey and Ms Stoughton put the level of harm at a lower level than do Historic England and Mr Eyre. As regards Middle Farmhouse, the dispute between the main parties to the appeal is whether the harm is accurately assessed as at the lower end of the spectrum of less than substantial harm, Dr Hickey, or the lowermost end of that spectrum, Ms Stoughton. Both of them put the level of harm at a lower level than does Mr Eyre. Dr Hickey identifies a higher level of harm to Stocks Farmhouse than do Historic England, Mr Eyre and Ms Stoughton, although Historic England and Mr Eyre position themselves only one category down from Dr Hickey, at the middle of the less than substantial harm spectrum rather than at the upper end of that spectrum. Moreover, Historic England does identify more harm within the middle category to Stocks Farmhouse than to either the church or the conservation area. Turning first to the church, it's common ground that as a Grade 1 listed building, the church is a designated heritage asset of the highest significance under the NPPF. Mr Ross's view is that any harm to the heritage significance of the church ought to be given more weight in the overall planning balance than harm to the heritage significance of less significant heritage assets. Against that context, it's surprising that the difference in opinion between Ms Stoughton and Historic England should be broadest in relation to the church. The explanation for that position is, however, simple. Ms Stoughton has entirely and erroneously overlooked the contribution that the rural character of the site makes to the heritage significance of the church, and her approach to invisibility as a contributor is also flawed. As regards the church, Historic England is correct to note that views of the tower from the north currently place the building in an attractive rural landscape, which enhances the aesthetic value of the building. The open fields within the site give a rural character to the wider setting of the conservation area and church when viewed from the north. Currently, it's possible to appreciate that the church is situated on the northern edge of the historic settlement and its rural context, because once you're beyond the immediate confines of the churchyard, the wider rural landscape is appreciable. the scheme would remove much of the wider rural landscape to the north of the church and would erode this understanding, and keeping the southernmost field within the site as open space would not prevent the scheme from causing a degree of harm to the significance of the church. Having regard to the conservation area appraisal, Ms Stoughton identifies the eastern field and the western fields as contributing to the heritage significance of the church, and also the area north of the western fields across which there's a clear view to the church. She confirmed in cross-examination that she considered the site to broadly fall within the open countryside to the north that's identified in the conservation area appraisal as creating an important setting to the church. But she had concluded that the site made no contribution to the heritage significance, that should say of the church, not of the site, because there was not a clear view from the site to the church. She also confirmed that it was only the clear viewpoint that had led her to distinguish between the site and the part of the open countryside to the north that she had identified as contributing to the heritage significance of the church. There are a number of flaws in Miss Stoughton's approach here. First, intervisibility is not the only respect in which the open countryside to the north of the church contributes to its heritage significance. The landscape character of that area also does so. Ms Stoughton agreed that it would be wrong to exclude part of a heritage asset setting as a contributor to the heritage asset's significance solely on the basis that there was no intervisibility. She also acknowledged that the conservation area appraisal identifies landscape character as a contributor to heritage significance. Ms Stoughton's evidence also identifies the wider agricultural surrounds beyond the eastern field and western fields as contributing to the heritage significance of the conservation area through historic illustrative value, that is, not through clear views or indivisibility. There is no justification for taking a different approach to the church, especially not when Ms Stoughton's evidence is that the church's heritage significance is further cemented by its location within the conservation area. Ms Stoughton conceded in cross-examination that part of the historical interest that the church derives from its setting is that its setting is rural. She was plainly correct to do so. Ms Stoughton contends that the views of the church from Brenda Park away do not illustrate its historic context in relation to the rest of the settlement, and that the context of the church within the settlement is not legible. Those views obviously do, however, illustrate the historical context of the church in terms of understanding its rural setting. Ms Stoughton's claim that it is not possible to appreciate the rural setting of the church in the view shown as her plate 20 is frankly fantastical. Moreover, Ms Stoughton's argument that the views shown in her plates 14 and 23 make a greater contribution to the heritage significance of the church is difficult to understand when those views include cars and modern built development. Secondly, even if it were appropriate to use intervisibility as the sole factor of distinction between the site and other parts of the open countryside to the north, which it's not, the basis for the distinction drawn by Ms Stoughton is not robust. It emerged in cross-examination that she had not actually entered the field from which she says that there is a clear view to the church. Additionally, Ms Stoughton discounted the site as a contributor to the heritage significance of the church on the basis of the current intervisibility between the site and the church, when her own evidence is that the scheme will create new publicly accessible views of the church from within the site. Thirdly, Ms Stoughton's approach to intervisibility as regards the church is inconsistent with her approach to intervisibility in relation to Fox Farmhouse, and I will turn to that point later. Ms Stoughton's continued insistence that the council's stance on the outbuilding, shown in plate 9 of her piece of evidence, is of extra relevance to this appeal, served only to emphasise that her assessment of the scheme's effect on the church is lacking in reality. The outbuilding is not remotely comparable to the scheme. Overall, the site plainly does contribute to the heritage significance of the church, and Dr Hickey is correct to have analysed the effects of the scheme on that basis. Ms Stoughton accepted that if the site does contribute to the heritage significance of the church, as the council contends, then the scheme would cause some harm to that significance. Turning to Stocks Farmhouse, as I've noted, like Dr Hickey, Historic England identifies as a higher level of harm would be caused to the heritage significance of this heritage asset than to the others that are relevant to this appeal. Its view is that Stocks Farmhouse derives its significance not only through its artistic and historic interest as a good example of an early 19th century farmhouse, but also from its illustrative value as the core of a historic farmstead, which has close connections with its immediate rural landscape. It still has a close visual relationship with the open land adjoining, which once formed part of that farm. Historic England identifies that the scheme would have a significant impact on the asset, as it would remove all its rural landscape setting. Ms. Ryan expresses her disagreement with the Heritage Statement's conclusion that the wider landscape only makes a minor contribution to Stocks Farm's significance, or that there would be a low level of harm to the significance. She notes that whilst the area closest to the asset would be open space and is planned for a balancing pond, it would nevertheless remove the wider open landscape that is currently appreciable from Stocks Farm. Ms. Stoughton was only prepared to acknowledge that the scheme would cause Stocks Farmhouse to lose a lot of its rural landscape setting, arguing that a very small amount of historical interest would be retained because glimpsed views would remain possible through the scheme, agricultural land that would remain to the other side of the site. She did recognise that there would be a very great reduction in the asset's rural landscape setting, with the loss of most of it. In reality, Stocks Farmhouse plainly would lose the entirety of its immediate rural landscape setting. If Miss Stoughton is correct to argue that a very small amount of historical interest would be retained courtesy of the glimpsed views, it follows that a very large amount of historical interest would be lost to the scheme. Miss Stoughton's analysis places too much emphasis on the absence of any designed views in the direction of the site. There's no evidence that views out of the property were designed beyond a functional preference to avoid views out over the farm buildings. Historic England was correct to reject the argument that the wider agricultural surrounds only make a minor contribution to the heritage significance of Stocks Farmhouse because, amongst other things, of the absence of design views out towards the site. It's difficult to square Miss Stoughton's assessment of the harm to Stocks Farmhouse as lower with her assessment of the harm to Middle Farmhouse as the lowermost. Miss Stoughton's justification for a conclusion of lowermost in relation to Middle Farmhouse is that in her view there is a very weak visual connection to the site and no built form is proposed to come forward within the setting of the heritage asset. Neither of those considerations obtains in respect of Stocks Farmhouse, where there is a very strong visual connection, and would expect a more significant difference between the conclusions reached as regards the two assets. And Miss Stoughton's approach to Stocks Farmhouse is also inconsistent with her approach to the church. If it's right that the retention of glimpsed views would enable some of the historical interest of Stocks Farmhouse to be retained, it is also right that glimpsed views of the church from within the site contribute to the historical interest of the church. Miss Stoughton's insistence that the scheme would not have any adverse effect on the significance of the church is thus unconvincing in the light of her analysis in relation to Stocks Farmhouse. Dr. Hickey's conclusion of less than substantial harm at the upper end of the spectrum is justified. Any suggestion that such a conclusion is approaching the level of knocking the heritage asset down is premised on an erroneous understanding of the case law on substantial harm, which is now set out in the Holocaust Memorial Judgment. See in particular paragraph 53 of that judgment. The off-site incident in Bedford did not import a test of draining away to a test of substantial harm, and there should not be any gloss on that term. As regards Middle Farmhouse, the dispute between the main parties is whether the level of less than substantial harm caused would be at the lower or lowermost end of the spectrum. Dr. Hickey's conclusion of lower should be preferred. He is plainly correct to observe that the property was not designed to face away from the site onto the street. Miss Stoughton accepted that if Dr. Hickey were correct on that point, the contribution to heritage significance that's summarised in the second row of her table decrease, and the relative contribution of the other rows, which include within the final row the contribution made by the site, would increase. Secondly, any suggestion that the community orchard proposed as part of the scheme would recreate the orchard that appears previously to have formed part of the farmstead and would thus somehow lessen or mitigate the harm that the scheme would cause to the heritage significance of Middle Farmhouse is unrealistic. The community orchard will not be understood as being part of the farmstead. On the conservation area, since there's no dispute between Dr. Hickey and Ms Stoughton on the level of harm that would result to the heritage significance of that asset, I do not comment further. Similarly, on the non-designated heritage assets even, the position is the same, and so again, I don't comment further. I turn to methodology. Whilst trenchant, the appellant's criticisms of Dr. Hickey's methodology are unfounded, and in any event, they lead nowhere. They amount to a valiant attempt to distract from the fact that it is Miss Stoughton's conclusions that are unsupported by either a transparent methodology or by the views of the other parties who've assessed the scheme's heritage effects. Methodological criticisms lead nowhere because you so reach your own view on the heritage effects of the scheme, employing whatever methodology you prefer. But for completeness, first, the appellant's double counting criticism is manifestly unfounded. It remains entirely unclear in what respect precisely Dr. Hickey is said to have erred. In his cross-examination, the suggestion was that the vertical heritage value axis of his Table 1 ought to be left out of account entirely, and that only the horizontal magnitude of impact of change axis ought to be taken into account in assessing the level of harm to the heritage asset for the purposes of the NPPF. The vertical axis of Dr. Hickey's Table 1, however, inputs the outcome of assessment against his Table 2, and Ms Stoughton accepted that Dr. Hickey's Table 2 accorded with her approach. She resiled from the suggestion that the entire axis should be left out of account. In Dr. Hickey's cross-examination, the criticism seemed to relate to his inclusion within Table 2 of references to the listing of the asset as Grade 1, Grade 2 star, Grade 2, and so on, but Ms Stoughton acknowledged that whether, for example, the architectural interest of an asset was of local, national importance, and so on, had factored into her calculation of harm. Secondly, the NPPF requires harm to the significance of a heritage asset to be assessed. It is impossible to undertake that task without first understanding and identifying the significance of the asset. This is really the end of the double counting point, because it's clear that the NPPF requires the significance of the assets to be taken into account in assessing whether there would be harm to that significance, and if so, to what degree. And the NPPF requires greater weight to be given to the conservation of more important assets. An element of double counting is thus innate in the provisions of the NPPF. Dr. Hickey was correct to observe that double counting is what the NPPF asks us to do, and also to observe that the mandated approach is not accurately described as double counting, because the first step, the consideration of significance, in order to assess the level of any harm to that significance, pertains solely to the heritage assessment, whilst the second step, the giving of greater weight to the conservation of more important heritage assets, falls to be undertaken as part of the overall planning balance. The planning practice guidance under the heading "What approach can be taken to assessing the impact of development on World Heritage Sites" expressly states that applicants may find it helpful to use the approach set out in the International Council on Monuments and Sites Heritage Impact Assessment Guidelines. That is a reference to the ICOMOS guidelines upon which Dr. Hickey's methodology is based. The ICOMOS guidelines explain that the significance of the effect of change, that is the overall impact, on an attribute is a function of the importance of the attribute, that's Dr. Hickey's vertical axis, and the scale of change, which is Dr. Hickey's horizontal axis. See also the table that follows in the ICOMOS guidelines and takes the same approach as Dr. Hickey's Table 1. There's no reason why the ICOMOS-based methodology advised by the PPG in relation to World Heritage Sites should not be applied to other heritage assets. Ms Stoughton acknowledged that the relevant passage of the PPG is not concerned with EIA or the contents of an environmental statement. It provides guidance to assist in the application of policies within the NPPF. The NPPF identifies World Heritage Sites together with, amongst other assets, Grade 1 listed buildings like the church, as heritage assets of the highest significance, and requires the same overall approach to be taken to World Heritage Sites as to other heritage assets, including listed buildings and conservation areas, as Ms Stoughton also agreed. Moreover, the table at the table at page 9 and 10 of the ICOMOS guidance makes express provision in respect of both World Heritage Sites and other heritage assets. The appellant is therefore wrong to contend that under the NPPF it's impermissible to take heritage value, the vertical axis in Dr. Hickey's Table 1, into account when assessing the harm that would be caused for heritage assets significance, because that approach would result in impermissible double counting. The PPG expressly suggests that such an approach might be helpful in relation to World Heritage Sites, which are recognised in the NPPF as internationally recognised to be of outstanding universal value. If such an approach is acceptable as regards heritage assets of outstanding international value, there is no justification for taking a different approach in relation to the heritage assets with which this appeal is concerned. Furthermore, the environmental statement chapter on heritage was authored by Ms. Stoughton and uses a tabular methodology adapted from the ICMOS guidelines, which considers heritage value of receptor together with magnitude of impact to reach a conclusion on the overall significance of effect, see Table 8.4. Paragraph 743 of the chapter states that professional judgment has been used to equate the results of the ES process with the requirements of the NPPF. Ms. Stoughton initially confirmed that she had translated the whole of the Table 8.4 results to her NPPF assessment, but later claimed that actually in translating the ES results to the NPPF assessment, she'd only inputted the magnitude of impact aspect of the Table 8.4 results. That's not explained in the ES chapter and in any event would result in the significance of the scheme's effects on heritage assets being higher in the environmental statement than under the NPPF. There's no justification for there being any difference between the two analyses. And for the same reason, Dr. Hickey was correct to observe that his Table 1 doesn't work if one attempts to use the results of the application of the horizontal axis in isolation. Historic England had sight of the ES chapter on heritage and did not suggest either that there was anything wrong with its methodology, including Table 8.4, or that it was impermissible to translate the results of the ES chapter to an NPPF assessment. Mr. Ayres also plainly translated the results applying Table 8.4 of the ES chapter to his NPPF assessment. There was no suggestion from the then applicant, now the appellant, that he was wrong to do so. Dr. Hickey's methodology is obviously more transparent than Ms. Stoughton's. He sets out clearly in his Table 4 how he translates the results of his Table 1 exercise to the NPPF assessment. Ms. Stoughton's written evidence offers scant explanation of how she performs that step, and to all evidence of the inquiry did not enable her approach to be scrutinised to the same degree as the appellant was able to test Dr. Hickey's methodology. The appellant's double counting point is unsupported by any case law authority, and nor is there even a single appeal decision before the inquiry that identifies that Dr. Hickey's approach is inappropriate. Because he accepted that his methodology was untested in the sense that there are no case law authorities or appeal decisions before the inquiry that demonstrate acceptance of the methodology, there was no challenge to his oral evidence that if he had had notice of the point that the appellant was going to take, he would have been able to provide relevant appeal decisions to the inquiry. Importantly, any suggestion that Dr. Hickey's methodology has led him to the wrong conclusions is entirely unsupported by the views of Historic England and Mr. Ayres. Overall, Dr. Hickey is not an outlier. It is Ms. Stoughton who overall puts the level of harm to the relevant assets at a lower level than the other parties who have considered the matter. It is very surprising that the appellant should embark on criticisms of Dr. Hickey's mapping in circumstances where it's common ground that mapping is neither required but nor prohibited by any Historic England, DLUC, PINS or council document, and Ms. Stoughton has made no attempt to illustrate what she considers to be the setting of each relevant heritage asset. The identification of setting provided in a narrative manner in her proof is extremely partial. It didn't enable the council even to understand the extent to which the site or parts of it were accepted by Ms. Stoughton as falling within the setting of any of the relevant heritage assets. That important point had to be established in cross-examination. It doesn't enable the reader to understand what proportion of an asset setting would be affected by the scheme, and nor does it enable the reader to interrogate whether Ms. Stoughton has drawn the line in an arbitrary manner or in the wrong place. Ms. Stoughton's approach is, in this regard as well, manifestly less transparent than Dr. Hickey's. Any criticism of the duration of Dr. Hickey's site visit is groundless. Dr. Hickey has decades of heritage experience, and he should be credited with the ability to decide how much time is required. Neither the extent of a heritage asset setting nor the contribution that that setting makes to the significance of the heritage asset are necessarily capable of full understanding from a site visit alone, as Ms. Stoughton agreed, and see also the relevant Historic England guidance. Nothing turns on the fact that Dr. Hickey undertook his site visit after he had accepted instructions. There's been no suggestion from the appellant that his evidence to this inquiry is anything other than his true professional opinion. Finally, as regards methodology, no weight should be given to the oral evidence provided to the inquiry in relation to the appellant's harmometer concept not put forward by Ms. Stoughton. Dr. Hickey was clear that he considered the concept to be logarithmic with a sudden major change after 9, and that he had simply been going along with the line of questioning from the appellant. I turn next to the weight to be given to the views of Historic England. Great weight should be given to the views of Historic England as a statutory consultee. The Court of Appeal confirmed as recently as July last year in relation to Natural England that the decision maker is entitled to be expected to give significant weight to the advice of an expert national agency with relevant expertise in the sphere of nature conservation. See the Wyatt case. The decision maker may lawfully disagree with and depart from such advice, but if it does, it must have cogent and compelling reasons for doing so. The Wyatt approach applies not only to Natural England, but to statutory consultees generally. The recent High Court judgment in the Newcastle case doesn't alter the above position at all. First, it's a High Court judgment and so is legally incapable of disturbing the Court of Appeal's decision in Wyatt. Secondly, whilst the defendant in Newcastle submitted that the case law authorities did not, in effect, establish the Wyatt principle, Mr. Justice Holgate did not reach a conclusion on that point, instead proceeding on the basis that the Wyatt principle was applicable. He explained that there hadn't been a full argument on the appropriate legal test and that it was unnecessary for him to resolve the issue in order to decide the matter before him. The appellant has indicated that it will refer in its closing submissions to an article in the Journal of Planning and Environmental Law. As to that article, in the Council's submission, it should be given no weight at all in the determination of this appeal. It is authored by 2 barristers, and the Council is not aware that it has been endorsed by the courts. The position expressed in the article is not binding on anyone, and there is no legal duty whatsoever upon you, sir, to agree with that position. The focus of the article is largely on the situation in which a statutory consultee appears at an inquiry as a Rule 6 party and calls its own witnesses to give evidence at that inquiry. See the reference to the Steer case, where the authors of the article note that in Steer, the Hart principle, so which is another reference to what I've named the Wyatt principle, was applied to the views of Historic England in the context of a planning appeal that was determined following an inquiry. In that case, Historic England had raised written objections but did not appear at the inquiry or call any witnesses. Again, this fact is significant as we've explored below. See also the author's later observation that whilst there's a wealth of case law on the principle that reaffirms its basic tenets, the point at which the Hart or the Wyatt principle hits the buffers is when it's invoked in planning inquiries where statutory consultees appear and call expert witness evidence, and where there's competing expert evidence called by the appellant or applicant. This is not such an inquiry. Historic England, of course, has not appeared. Thirdly, the authors of the article identify the Hart case as the apparent origin of the Wyatt principle, and the article explores how the principle has evolved through subsequent case law authority. Yet in Hart, in which the statutory consultee Natural England had not appeared at the inquiry, the court was very clear that whilst the weight to be given to the views of Natural England was a matter of planning judgment for the decision maker on appeal, a choice not to give considerable weight to the views of the statutory consultee would have required some cogent explanation. The basic tenets of the principle are thus long-standing. Finally, none of the appeal decisions in front of the inquiry are examples of less than great weight having been given to Historic England's views. The Council, of course, does not suggest that Historic England's views are binding on you, sir. Those views do, however, deserve great weight unless a cogent and compelling reason can be identified for giving those views less than great weight. Any other approach is contrary to Court of Appeal authority. There is no cogent and compelling reason to give less than great weight to Historic England's views here. As to the Swainsthorpe case, the Council does not suggest that great weight should be given to Ms. Ryan's views on housing need or planning policy considerations. However, the fact that Miss Ryan commented on the housing need position in her first consultation response does not provide any reason, still less a cogent or compelling one, for affording less than great weight to her views on the heritage effects of the scheme. Miss Stoughton notes in her proof that Miss Ryan was challenged on her consideration of matters relating to housing need. Miss Ryan's response was to stand by her initial assessment of the harm that the scheme would cause of heritage significance of the relevant designated heritage assets. Miss Stoughton agreed that Miss Ryan's consideration of housing need matters had not affected her assessment of the effects of the scheme on heritage significance. The planning policy considerations part of Miss Ryan's initial consultation response is separate to and follows her assessment of the heritage effects. Next, Miss Stoughton is wrong to suggest that the assessment of harm made by Miss Ryan appears at odds with Historic England's earlier screening response. First, it should be noted that at the screening stage, Historic England's view was that the heritage statement was inadequate, with omissions, notably a lack of photographs from designated assets towards the development site, which makes assessment difficult. Secondly, and as Miss Stoughton agreed, all that the consultees who responded at the EIA screening stage were considering was whether the scheme was likely to have significant effects. They weren't assessing the scheme's performance against the NPPF's heritage policies. As Miss Stoughton accepted, it's not possible to equate a conclusion of not significant for EIA purposes with the conclusion of no harm for the purposes of the NPPF. The threshold of significance for EIA purposes can be placed at a level above some level of harm. See, for example, the appellant's approach to landscape character and visual effects and the related discussion at section 4 of Dr. Hickey's proof on landscape matters. In short, it's possible for there to be harm that's not assessed as significant for EIA purposes, but that still amounts to less than substantial harm under the NPPF. There's no merit to Miss Stoughton's contention that one can accurately translate Historic England's position in its screening response into an NPPF assessment so as to show that the screening response is inconsistent with Ms. Ryan's later assessment. To do so, Miss Stoughton had to deploy her own methodology, which would of course have been unknown both to the author of the screening response and to Ms. Ryan. Importantly, Historic England in its screening response does not actually reach any conclusion as to whether the scheme would harm the heritage significance of the church, explaining that it's not possible to assess whether there's no harm. All that's stated is that Historic England anticipates the impact not to be significant. Similarly, in relation to Middle Farmhouse, the screening response states the impact of the scheme cannot be easily assessed, and again, by way of conclusion, states only that Historic England would not anticipate the impact to be significant. Ms. Stoughton accepted that Historic England was not, in its screening response, actually reaching any conclusions on whether the scheme would cause harm, and that whilst in her view Historic England was open to an eventual conclusion of harm, it was equally open to an eventual conclusion of harm. Moreover, there is much that is consistent between Historic England's screening response and Ms. Ryan's later analyses. Even at the early stage of producing its screening response, Historic England noted the conservation area is bounded by fields, showing the important relationship between the village, the farms, and the wider landscape. The historical associations of Stocks Farm with the site were also noted, along with the close visual relationship of the open land adjoining which once formed part of that farm. In respect of the church, the screening response drew on the conservation area, the appraisals highlighting of the importance of open spaces within the conservation area, and it's noting that in particular, the open countryside to the north contributes to the setting of the village and especially to the church. And this reference to the conservation area appraisal accords with Miss Stoughton's own approach. On the conservation area itself, Historic England identified a likely impact as some of the wider agricultural landscape would be lost. Next, there's no legitimate basis for an assumption that Ms. Ryan did not undertake a site visit. The position in that regard is simply unknown. Equally, the fact that Historic England has not appeared at the inquiry is entirely unremarkable. Any suggestion that it does so, and I'd add, or that it is able to do so, every time that it identifies less than substantial harm in the middle of the range to a designated heritage asset, even one of the highest significance, would be unevidenced. There are numerous case law examples in the JPL article of great weight being given to Historic England's views, even though it didn't appear at the inquiry, such as its position wasn't tested through cross-examination. Nor can the fact that Ms Stoughton disagrees with Historic England amount to a cogent and compelling reason to give less than great weight to Historic England's views. If that were the position, the Wyatt principle would be largely deprived of any practical effect. Similarly, the fact that Historic England does not agree with Dr. Hickey's assessment in relation to all 4 designated heritage assets that are an issue here is not a cogent and compelling reason in the context of the Wyatt principle either. They are in agreement as regards the church, which is the most important heritage asset, and they're not far apart from each other in relation to the other 3 designated heritage assets. So in the light of all of the above considerations, I invite you, sir, to prefer Dr. Hickey's assessment of the harm to heritage significance that would result from the scheme. I then turn very briefly to the 6th reason for refusal and the effect of the scheme on the capacity of existing sewage drainage systems. The Council remains of the view that the requisite planning conditions should be drafted as it suggests, see the wording set out above paragraph 8.3 of the relevant statement of common ground. It notes that Thames Water does not suggest that any provision with planning condition with respect to temporary arrangements is necessary. Furthermore, the appellant's stance does not accord with paragraph 188 of the NPPF referred to by the appellant yesterday, since any need for provision to be made in respect of temporary arrangements requires one to assume that Thames Water will not discharge its statutory duties effectively. As to the 7th reason for refusal, which relates to the section 106, if the provision made in the unilateral undertaking, as amended pursuant to yesterday's session, in relation to the public right-of-way contribution is maintained in the unilateral undertaking, then the Council no longer pursues the 7th reason for refusal. However, in the event that that provision is removed from the unilateral undertaking, the Council does maintain this reason for refusal. The public right-of-way contribution plainly satisfies the requirements of Regulation 122 for the reasons articulated by the County Council in Inquiry Document 19. The County Council has informed the Local Planning Authority that until the day before the inquiry session on Section 106, its understanding was that the public right-of-way contribution was agreed by the appellant. It's for that reason, having only been notified of the change in position the day before, that the County Council was unable to attend yesterday's session. On the other adverse effects of the scheme, it's common ground that the scheme conflicts with both Local Plan Policy SS6 and Neighbourhood Plan Policy H1, but that limited weight should be given to that conflict. Any point in respect to Article 35 of the Development Management Procedure Order goes nowhere, given that Mr Ross and Mr Dawes are in agreement on this issue. On Mr Ross's case, moderate weight also falls to be given to the loss of MP. I turn to the benefits of the scheme. First of all, housing. Considerable weight should be afforded in the overall planning balance to the provision of market housing and significant weight to the provision of affordable housing. Context for that weighting is that, as is common ground, the weight to be given to the provision of housing is at large under the NPPF, even where there is no 5-year housing land supply. Secondly, the current shortfall against the 5-year housing land supply requirement is moderate. And thirdly, planning permission has already been granted for significantly more than the local plan requirement of 200 units for Bramley. The Council notes that the appeal decisions referenced at paragraphs 214 and 215 of Mr Ross's proof do not evidence that inspectors have consistently given the highest possible weighting to the provision of housing. They evidence only that they have given it the highest weighting in relative terms, which is the approach that Mr Dawes has taken. For the reasons articulated by Mr Dawes in the roundtable session, which I don't attempt to summarise in my closing submissions, the Council considers that it has taken a robust approach to the calculation of its housing land supply. You will recall, sir, that Mr Ross acknowledged that the Council had addressed the point that he had raised in relation to the station road scheme on annexes, and that he wasn't on this occasion challenging the quality of the data. Following the roundtable session, it's common ground that the true housing land supply figure is probably somewhere between 3.71 years and 4.6 years. The Council remains of the view that it is very much closer to the latter than the former. In particular, the recent momentum on Manydown does justify some figure being included in respect of that site. On the other benefits of the scheme, I deal first with the community building. The Council doesn't dispute that this would be of some benefit. However, despite its name, it would not be able to fulfil the need identified in the neighbourhood plan for improvements, extensions to Village Hall, because planning permission is sought for a Class E use, not for a Class F use. Mr. Ross's insistence that the potential for part of the community building, which is to be up to 250 square metres, to accommodate a new shop should on its own be afforded the same significant level of weight as both the provision of market housing and the provision of affordable housing is not remotely persuasive. The expression of interest simply refers to great retail potential. Mr. Ross acknowledged that it was not purporting to be an assessment of need. There's no justification for affording the remainder of the community building significant weight either. The prospect of surgery use is a possibility, not a commitment at this stage, and it emerged for the first time in Mr. Ross's cross-examination that what is actually suggested is a storage or back office use of the floor space. Mr. Ross conceded that he couldn't set out that there was any specific need for a local business space or hot desking hub. The appellant cannot convincingly argue that the scheme's housing provision attracts significant weight on the basis of need, whilst simultaneously arguing that the same weight should be given to scheme benefits in respect of which it accepts that the need case has not been evidenced. The Council agrees that the economic benefits of the scheme attract significant weight taken together, and that position is consistent with paragraph 81 of the NPPF. But that paragraph does not require significant weight additionally to be given to the potential new shop or to the potential business space within the community building individually. Mr. Ross notes that the views of inspectors do diverge on paragraph 81, but paragraph 150 of the Yatton appeal decision does not support an argument that economic benefits must be weighed in the overall planning balance in a blanket fashion, no matter how large or small. As is the case under the NPPF heritage policies, the weight to be applied is prescribed and it's the same. It's great in the heritage context and significant under paragraph 81, but the heritage harm or the economic benefit in question might be bigger or smaller. Turning to the skate park again, the argument that this benefit attracts the same significant weight as the scheme's housing provision is unconvincing, to say the least. Mr. Ross agreed that there's no evidence that the local community supports delivery of the skate park on the site. As to open space, Mr. Ross acknowledged that the over-provision is at least partly the result of the need to mitigate the adverse effect of the scheme on heritage assets, landscape character and visual receptors. The appellant went back to Neighbourhood Plan Policy RE2 in re-examination. Any submissions in reliance on that policy should be disregarded entirely. Mr. Ross's position was that it was not even a relevant policy for the determination of this appeal. Policy isn't referenced in his proof and was mentioned for the first time in his evidence in chief. The council has had no opportunity at all to question any other witness about it. The justification for the scheme's allotments is identified in the main statement of common ground as being the need to meet the additional pressure that would arise from the scheme on existing allotments. Finally, Mr. Ross's attribution of moderate weight to the sustainable location of the site is not justified by the Silchester Road appeal decision, which doesn't ascribe any specific weighting to sustainable location in the overall planning balance, nor does sustainable location feature Mr. Ross's comparison table of appeal decisions at paragraph 861 of his proof. In the light of those points, the more measured weightings given to the scheme's other benefits by Mr. Dawes should be preferred. I turn then to the overall planning balance. First, non-compliance with the development plan as a whole. The scheme conflicts with local plan policies EM1, EM10, EM11 and SS6, and with neighbourhood plan policies D1 and H1. As such, it fails to accord the development plan overall. The conflict with policies SS6 and H1 is common ground, as is the limited weight to be given to that conflict. It's also common ground that notwithstanding the absence of a 5-year housing land supply, full weight should be given to any conflict with policies EM1, EM10, EM11 and D1, and that if those 4 policies are breached, there is non-compliance with the development plan overall. The dispute between the main parties, therefore, is whether there is any conflict with those 4 policies. The appellant's case is that it accepts that the scheme will cause some landscape character and visual harm and also some harm to the heritage significance of both designated heritage assets and non-designated heritage assets, but it contends that all such harm falls within the tolerance of the policies such that they're not breached. It was put to Mr. Dawes and he agreed that in order to be beyond the tolerance of the policies, we should be looking for something beyond the inevitable consequences of greenfield development in the countryside. Whilst Mr Ross demurred on this point, in the council submission it does logically follow from that position that if the scheme harm does exceed the inevitable consequences of greenfield countryside development, it will exceed the tolerance of the policies. The harm that the scheme would cause goes very far indeed beyond the inevitable consequences of greenfield countryside development. As Mr Ross agreed, it's not an inevitable consequence that there will be any harm to the heritage significance of designated heritage assets. It's certainly not an inevitable consequence, not even in Bramley, that there will be harm to the heritage significance of a designated heritage asset of the highest importance, such as the church. It is not inevitable either that there will be harm to the heritage significance of a designated heritage asset of the highest importance and to that of 3 additional designated heritage assets. It's not an inevitable consequence that there will be views from not 1, not 2, but 3 public rights of way that run along the site's boundaries, nor is it inevitable that one of those will be a very well used long distance path. It is not an inevitable consequence that the proposal will harm specific views that the development plan identifies as important, and it is most certainly not inevitable that the proposal will result in harm to the heritage significance of 4 designated heritage assets, including one of the highest significance, and views of the proposal from public rights of way running along 3 of its 4 sides, and harm to specific views that are identified as important in the development plan. It's not inevitable either that where residential development is proposed for a greenfield countryside site, it will be proposed in a settlement that's already delivered more than 170% of the at-least figure for housing that's identified in the development plan. As the position here, Bramley having delivered 347 units against an at-least requirement of only 200 units. Indeed, the appellant is not contending that such an outcome is inevitable because Mr Ross said that he didn't know whether it was. It is important to recognise that there is no specific need for more housing to come forward in Bramley, in the sense that there's no policy requirement that it should do so. The at-least figure of 200 units stipulated in the development plan has not only been achieved, but has been very well exceeded. In reality, the harm that the scheme would cause goes so far beyond the inevitable consequences of greenfield countryside development that even if the tolerance of the policies extends beyond such consequences, and you'll recall there Mr Ross's reference in cross-examination to a grey area, that tolerance is still exceeded. Mr Ross's position in cross-examination was that if you, sir, agreed with Dr Hickey's assessment of the harm to the heritage significance of Stock's farmhouse as lying at the upper end of the less than substantial harm spectrum, it would be very hard to say that there's not a breach of the development plan. He also noted that harm in the middle of the less than substantial harm in the middle of the less than substantial harm spectrum to the church was probably going beyond the tolerance of the policy, and he subsequently agreed that there would in those circumstances be a breach of both policy EM1, EM11 and policy D1. An attempt was made in re-examination to row back on this latter point by suggesting that it was inconsistent with Mr Ross's answers on the position under the MPPF if the council's case on harm to heritage significance was accepted. There's no reason, however, why Mr Ross's answers in relation to policy EM11 and policy D1 should be assumed to be the cause of any such inconsistency. In the council submission, the better explanation is that Mr Ross's answers in respect of the MPPF were inconsistent with his earlier answer as regards policy EM11 and policy D1. It is common ground that it would be open to you, sir, to find a breach of policies EM1, EM10, EM11 and D1, even if your conclusion on the harm that the scheme would cause either aligns with the appellant's case or falls somewhere between the respective cases of the council and the appellant. In the council's submission, the appellant has grossly exaggerated the tolerance of the policies here. See, for example, Mr Smith's insistence that there would be no breach of policy D1, even if the scheme would have a major moderate adverse visual effect on a neighbourhood plan important unit like EM15. The appellant doesn't appear to have understood the extent to which the adverse effects of the scheme would exceed the adverse effects that can be expected of any greenfield countryside development. As repeated emphasis was placed by the appellant on the agreement stated in the landscape statement of common ground, that it's inevitable that all greenfield residential developments will result in at least localised landscape and visual harm. It's not the case, however, that such harm will always be of the same significance as Mr. Smith agreed. The outcome depends on variables such as the value of the site and the sensitivity of the receptor. Whilst Dr. Hickey accepted that the description of change column in his table of visual effects would apply to pretty much any greenfield development, the other columns in that table, magnitude, sensitivity, and significance, would vary, as Mr. Smith agreed. Mr. Smith also acknowledged that you have no proper evidence before you, sir, of how the nature and significance of landscape and visual harm here compares to the nature and significance of landscape and visual harm that would arise if an alternative greenfield countryside site were developed elsewhere in the borough. We do know, as Mr. Smith agreed, is that 23% of the sites assessed in the LSS were found to be less sensitive than the appeal site. Mr. Smith accepted as well that it hadn't been shown that the council could not achieve its housing requirement on sites that were less harmful in landscape and visual terms than the development of the site would be. There was some suggestion from Mr. Ross in the examination that there were no other suitable sites in Bramley. That suggestion isn't properly evidenced and is in any event nothing to the point in circumstances where there's no policy requirement, nor even a policy expectation for more housing to come forward in Bramley. In the light of those points, no weight should be given to any argument that the harm that the scheme would cause is either wholly or largely inevitable because the council has no 5-year housing land supply and acknowledges that development will need to come forward on greenfield countryside sites. It's also important to bear in mind that, as Mr. Ross agreed, even where 5-year housing land supply is absent, the NPPF doesn't operate so as to grant planning permission for housing schemes automatically. There's no requirement either in legislation or in policy for a local planning authority to have a 5-year housing land supply come what may, that is, irrespective of the cost in terms of adverse effect on the landscape, heritage assets, and so on. In circumstances where the scheme does not accord with the development plan overall, Section 38(6) of the 2004 Act requires planning permission to be refused unless material considerations indicate otherwise. They do not. The NPPF is an important material consideration. Applying paragraph 11D of the NPPF, the policies that are most important for determining the application are deemed to be out of date because the council can't demonstrate a 5-year housing land supply. However, paragraph 11D(1) is engaged because the application of the NPPF's policies on designated heritage assets does provide a clear reason for refusing the scheme. That's because applying paragraph 202 of the NPPF, the public benefits of the scheme don't outweigh the harm that it would cause to the heritage significance of the relevant designated heritage assets. It's common ground that whilst the analysis under paragraph 202 requires only the harm to the heritage significance of the designated heritage assets to be weighed against all of the public benefits of the scheme, the balance is a flat, not a tilted one. That is, the requirement is simply for the heritage harm to outweigh the public benefits. In contrast to paragraph 11D(2) of the NPPF, there's no requirement that it do so significantly and demonstrably. Mr. Ross also agreed that in undertaking the paragraph 202 exercise, great or considerable importance and weight had to be given to each instance of heritage harm, that is, in respect of each designated heritage asset. It should be noted that Mr. Ross agreed that if the conclusion reaches that the scheme would harm the heritage significance of the church, the limited weight that he ascribes to harm to setting of listed buildings in his table at paragraph 1027 of his proof would need to be revised to somewhere between moderate and significant. It's common ground that if the scheme does not pass paragraph 11D(1) of the NPPF, the analysis doesn't continue to paragraph 11D(2) of the NPPF, which is a tilted balance. If, contrary to the council's primary case, the scheme does pass paragraph 11D(1) of the NPPF, it's common ground that under paragraph 11D(2), all of the other scheme harm has to be added into the balance, whilst the public benefit side of the balance remains the same as under paragraph 11D(1). It's also common ground that that other harm comprises the harm to the non-designated heritage assets, the harm identified under reason for refusal 1, so the landscape character, visual and settlement pattern harm, the conflict with policies SS6 and H1, which attracts limited weight, and on Mr. Ross's case, the loss of B&V. When all of the adverse effects of the scheme are weighed against its public benefits, the latter are significantly and demonstrably outweighed by the former. Therefore, even if the tilted balance is applied, it again indicates that planning permission should be refused. To conclude, sir, the council acknowledges the extent of its present need for housing, both market and affordable. It does not follow from the extent of that present need, however, that it must be satisfied irrespective of the adverse effects of the relevant proposal. As Mr. Ross agreed, the effects of the scheme might well last for longer than the current absence of a 5-year housing land supply. The appellant's apparent suggestion that the adverse effects of the scheme are largely, if not entirely, simply the adverse effects that the council must unavoidably tolerate because it doesn't have a 5-year housing land supply at present is fallacious. The adverse effects go very well beyond that. In consequence, the scheme fails to accord with the development plan, I should say, and material considerations do not indicate that planning permission should nevertheless be granted. This appeal should be dismissed and the permission should be refused. You said.
Sergeant, thank you very much indeed. Mr. Mann, should we take a short break before coming to
Your hands. Yeah, I'm ready to go, but equally, people may need a brief comfort break. So
10 minutes?
that's good.
That makes past back here for Mr. Banner's closing statements. Thank you very much.
Good. Yes, I try.
So one's important to everywhere on the earth.
We're at past. Mr. Banner, time for me to
Yes.
hand over the appellant.
Mr. Grant is going to circulate the relevant documents.
Thank you very much.
So, broadly speaking, most of the points made by the council we've preempted. There's a couple of places where I will have to add verbally, and I'll flag that up.
Just do.
Thank you very much. Thank you.
Very good. Mr. Banner, the thank you to yours.
So before delving into the detail of the issues debated at the inquiry, we stand back and make the following headline observations. Firstly, of the 7 putative reasons for refusal originally outlined, only 3 are still pursued. Oh, I'm asked to put the microphone on. So only 3 are still pursued. I'll come in due course to the half resurrection of reason 7 later, but only 3 are still pursued. And broadly, these relate to settlement pattern, landscape and heritage. Secondly, on the council's own case, it has had a 5-year housing land supply shortfall that has persisted for approaching 4 years, and that shortfall is growing. The obvious insufficiency of evidence to support the inclusion of many down the 5-year supply on its own takes the figure below 4 years. Thirdly, the affordable housing need is almost 4,500 households borough-wide, an increase of some 1,500 in the last 5 years. In Bramley alone, it's over 100 households. Fourthly, the council, through Mr. Dawes, accepts that it will have to build on unallocated greenfield sites if it's to stand any hope of regaining a 5-year supply, as they accept they must do. And the council also accepts this will inevitably lead to some harm somewhere, including at least localised landscape and visual harm. It's common ground that the landscape impacts and visual impacts of the appeal scheme would indeed be localised and were thought to be considered within the context of the tilt balance. And moreover, Mr. Dawes considers them to carry the least amount of weight of the 3 main objections put forward by the council: settlement pattern and heritage, carrying a higher level of weight on his scale. Sixthly, the settlement pattern objection was unsupported by any expert urban design evidence and was inconsistent with the council's case that all's to play for at the reserved matters stage in terms of the final layout, design, etc. Further, this objection has shrunk from alleged inconsistency with the prevailing character of Bramley as a whole, as set out in the reason for refusal and indeed the statement of case, to whether it's consistent with the particular parts of the street that mentions lay in the vicinity of the appeal site. And the council's produced no evidence on the wider characteristics of the village. Mr. Dawes also accepted that the appellant's been through a rigorous design process and that the design contained within the illustrative master plan could come forward. You can, should you wish, tie the development to the DAS. In relation to heritage, it's now common ground that if Ms. Stoughton's analysis is accepted, of course we say should be, the framework paragraph 202 test is satisfied. The public benefits outweigh the harm. And by the same token, so too are the applicable tests in local plan policy EM11 and the neighbourhood plan policy D1. Mr. Dawes also accepted in cross-examination that the only meaningful, for policy purposes, difference between Dr. Hickey and Stoughton relates to their assessment of the extent of harm to St James's Church, we say none, of course, and Stocks Farmhouse. We suggest, sir, that it's obvious by this stage of the inquiry that the real crux of this case turns upon your weighting of the public benefits on the one hand, the appeals scheme, against, on the other hand, your analysis of the extent of any harm to be identified to those two listed buildings, the church and Stocks Farm. We suggest that's really where the crux of it boils down to. And as to that, we say that the council has downplayed the weight to be given to the benefits of the appeal scheme, and conversely has exaggerated the effect of the development on the setting of the church. We say there's none. And at Stocks Farmhouse, we say low-end LTSH, not high-end, as contended for by Dr. Hickey. And that exaggeration is in considerable part due to Dr. Hickey's fundamentally flawed methodology, which, amongst other things, double counts the value or importance of the heritage asset. Double counts it this way. Firstly, in ascribing the level of substantial harm, that's a product, if you call it, multiplying the magnitude of impact against the level of gradation of listed building. And then a second time in paragraph 199, because the more important the asset, the greater the weight into its conservation of the ban. He did accept, contrary to one, if you give him for forgetting that he accepted in terms, forgetting from my learned friend's closing, he accepted in terms you double counted. But once you strip away the double counting, once you strip away taking into account importance in ascription of harm and save that for the paragraph 202.199 balance, the subscription of level of harm is broadly, not quite, but broadly the same ballpark as Miss Stoughton. Even if, however, you were to accept Dr. Hickey's exaggerated level of harm for the reasons Mr. Ross has given, his oral evidence, the many and substantial benefits of the appeal scheme would outweigh it. So against that overview, we then turn into, to a little more depth, some of the issues that discussed at the inquiry, starting with housing need. And within that, we address first housing land supply. The overall requirements agreed. The range, as you've heard, is agreed to be between 3.7 and 4.6. It's also agreed that 4.6 can be described as moderate and that 3.7 can be described as severe. We note, in terms of in between, that in Station Road, the council accepted 4.1 year supply would be a significant shortfall. A brief word on lapse rates. We accept that little may turn on this issue, but we suggest that, at least in isolation, it may aggregate cumulatively be of relevance. But Mr. Ross's stance is reliable, evident, and consistent with the position put by the council in the Station Road locally appeal. In relation to individual sites, we, for obvious reasons, start with many down. And if you agree with Mr. Ross's position, that alone takes the council's housing supply to 3.97 year supply, which Mr. Ross would like to describe as a severe shortfall. It's agreed that Maydown has stalled. Mr. Ross outlines as being persistent over-optimism in the council's suggestions, and under delivery dating back now virtually 6 years to 2017. Mr. Dawes suggested there's been, in his words, some momentum in the last few weeks and months, but with respect, the council hasn't provided the necessary clear evidence, and necessary it is given the status of that site as against the framework definition. The figure of anything other than zero should be awarded. In particular, though much is made of Urban and Civic's involvement, they've been involved since 2019, during which there's been little progress. They are, of course, not a house builder. Urban Civic may undertake some infrastructure works, but they'll need house builders to bring the housing forward. There's no indication, let alone clear evidence, that there are any such house builders or any tendering processes even started to bring them on board. There's an unusually complex set of conditions, in particular the highly elaborate condition 5 and 7 on the outline admission, which must be discharged before reserved matters can be sought. That will obviously be the subject of anxious scrutiny. The planning statement provided indicates there's already a proposed departure from what's been approved in the outline. And the council hasn't even approved its Maydown business plan or the land being acquired. Even if you were to agree with the council that some development is likely to come forward, the council has provided no clear evidence as to how reliable its trajectory figures are. We suggest that the 320 units per annum that they assume the site will build up to is highly ambitious and unevidenced. As for Saffron Lane, there's no clear evidence it is deliverable. It's allocated, but no permission has been granted. There are significant technical objections, including on highways grounds, And whilst the council asserted nutrient neutrality issues were resolved, there's nothing in the public domain on that, no clear evidence. Mr. Dawes indicated the only update beyond the position set out in the Scotch schedule is that some plans are going for consultation, but he may fairly accept that doesn't really help. In relation to Elmdene and Fairholme Road and the other sites, Mr. Dawes was unable to provide any more evidence than is set out in the Scotch schedule. He's asked if the council hasn't provided. They're not deliverable for the reasons outlined by Mr. Ross in the Scotch schedule and reiterated in the roundtable discussion. In terms of Evinger Road, there are significant outstanding highways objections to the Housing Authority. No cost of that being resolved. Reserve Matters application has been with the council for over a year and a half. And again, there's no indication to be granted anytime soon. All the evidence before you does point to non-deliverability. So pulling that together by way of some conclusions, there's unquestionably significant need for housing in this district. It's approaching 4 years since the council had a 5-year supply, and on their own figures, the shortfall was persistent and worsening. It's less than was claimed in the Oakley appeal, 4.8 odd, about a year, 18 months ago. The true position is a housing supply of decisively below 4 years, which on any tenor view is a severe shortfall. Nobody at the inquiry was able to say when the council would regain a 5-year supply. And what is clear and agreed is it won't be quick. The emerging local plan has no prospect of remedying the problem anytime soon. On the council's best case, it won't be adopted till late 2025. We all know that local plans have a habit of sometimes slipping. The affordable housing position is even worse. There are 4,466 households, not people, but households on the council's affordable housing register, an increase from just above 3,000 in 2016-17. And of those, 102 have a verified local connection to Bramley. Remarkably, the council doesn't accept that's a significant shortfall, although Mr. Dawes did agree in cross-examination that if, contrary to that analysis, the shortfall in affordable housing can indeed properly be described as significant, as surely it must, then the affordable housing delivery the appeal scheme would provide should be given the maximum level of weight on his scale, substantial. In the inquiry, the council also adopted the somewhat unusual position of indicating that notwithstanding the shortfall, there's no housing need in Bramley. That's a completely flawed approach. The policy is to deliver at least 200 homes in Bramley. And although 55 homes has been mooted for the emerging local plan, euphemistically described as paused, no weight can be placed on that. The figure is unevidenced and shorn of any district-wide context. There's a substantial district-wide need, having regard both to the existing shortfall, which the council accepts to be made up because it doesn't stop there. There's also then the ongoing needs rolling forward for future years. They too also have to be met on top of the shortfall. Bramley's a sustainable settlement, as you've heard from Mr. Bevis, and there simply isn't any evidence before you that there's no need there. The uncontested evidence to the contrary is that there are 102 households on the affordable housing register with verifiable links to Bramley. And it's also notable the council doesn't allege, nor could it properly be said, that the 140 dwellings proposed by the appeal scheme would change where Bramley sits in the settlement highway. They would compel effectively upscaling to a higher rung in the settlement highway, the latter. So that's not the case. Turning to the high quality of the appeal scheme, and it's common ground that the key question in this context is whether a high quality scheme is capable of coming forward at the reserve matters stage. And Mr. Dawes accepted in cross-examination that if the evidence justifies the conclusion that at the reserve matters stage the council could, if it's doing its job properly, secure a development which falls within either or both limbs, A and B, of paragraph 134 of the framework, then the significant positive weight which that paragraph refers to should be accorded to the appeal scheme in the planning balance. Well, the evidence for the inquiry, including the DAS and the evidence of Mr. Smith and Mr. Burton, amply demonstrates that is indeed the case. The illustrative master plan has been carefully and iteratively designed, taking into account the key constraints of the site. The DAS and Mr. Burton's townscape appraisal clearly demonstrate how the scale, layout, height, and density of the scheme would fit the village of Bramley. And Mr. Smith further explained in chief how the design process was informed by trying to complement and respect the views set out in the neighbourhood plan. And Mr. Dawes agreed in cross-examination that the process that the appellant had gone through was rigorous, that it was within the powers of the LPA to ensure a high quality built form and a high quality and quantity of open space. Turning then to paragraph 14, the result of that hard work is a high quality design. Whether you look at it from an urban design or landscape point of view, Mr. Burton's explained in detail and by reference to mapping, the history and the grain of the settlement density, analysis of built form, exactly how the development would comply both with national and with local policy and integrate with the surrounding character of the area. And he also addressed the particular issues raised in the first reason for refusal, showing through a comprehensive analysis that they are without foundation. Although Mr. Burton was the primary design witness, Mr. Smith undertook a landscape design review of the proposals and confirmed that the exceptional, I don't think they dispute about exceptionality, 76% of public open space with the community orchards, the meadows, the bowling green, allotment, the skate park, new hedgerows, trees and greenways would overall create an attractive and appropriate settlement edge. You'll form your own view about whether the settlement edge at the moment is appropriate on your site visit. Contrary to suggestions otherwise, it is manifestly not a stockhouse estate. So what's it against us? Well, the key point put by Mr. Dawes during the design-related cross-examination of evidence was the depth of the dwelling proposed. He said he wasn't in accordance with Minchin's Lane of the street, or at least the relevant part of those roads. And that's not because Bramley is linear, he accepted it wasn't, but he felt that the depth jarred with the edge of settlement locations. Then he expanded on your questioning, suggest our site was too big, regardless of the built form, with too much open space, and the skate park, which he felt was odd. Now, those points are without merit. There's no sound justification for the council artificially to narrow the point of comparison from the village to the bit immediately adjacent to the site. As Mr. Burton explained in chief, the type of ribbon development that Mr. Dawes would, it seems, prefer leads to inherently unsuitable development. It's not walkable, leads to poor frontages, surveillance issues, and inactive settlement edge. It wouldn't comply with the National Design Guide. It's not representative of Bramley as a whole. It's not even representative of the street and Minchin's Lane as a whole. If one looks at the actual village, as per the reason for refusal, the suggestion about depth is clearly answered by Mr. Burton's figures 5, 1, 2, and 3. And as explained in chief, the block structure isn't unusual in Bramley, particularly with the more recent development, such as St James's Park, let us not forget, all permitted by the council, and Bramley View. As to the other points, the skate park is sought by the neighbourhood plan, and there's no rational basis for criticising the development for providing too much open space. You heard from various witnesses, including Mr. Burton and Ms. Stoke, about how the DAS would form the starting point for preparation and evaluation of any reserve matters application. That's plainly correct. The council's attempt during the inquiry to suggest that the reserve matters stage would be some kind of unconstrained free-for-all, wholly divorced from the DAS, is entirely misconceived. It's contrary to planning practice, and it's actually contrary to planning law. The DAS would unquestionably be a legally obligatory material consideration for the reserve matters stage, which the council or inspector on appeal would be fully entitled as a matter of law to use as a reference point for evaluation of any reserve matters applications. Without the council felt compelled to take such a line at the inquiry, we suggest highly telling. The obvious inference is that their inquiry team did not feel confident in their ability to land any blows on the illustrative scheme of the DAS, and therefore felt it necessary to take the approach of suggesting that both were essentially meaningless to the evaluation of the scheme's eventual quality. As discussed prior to Mr. Ross's evidence in chief, should you feel it necessary to impose a condition requiring any reserve matters application to be broadly or in general accordance with DAS, plainly it's within your legal powers to do so, following the process which you've already outlined with regard to receiving submissions from the parties on that point. Turning then to, by way of headline, other benefits of the appeal scheme, there are a wide range of important benefits. Mr. Ross's proof outlines them. We adopt what he says there without in any way wanting to duplicate. We note market housing to meet the significant need occasioned by severe shortfall, affordable housing ditto, the community building, which could provide a shop east of the railway line space to help meet the neighbourhood plan's aim of improving the medical practice. The skate park has sought in the neighbourhood plan. 76% open space, 900% more than the current Fields and Trust standards requirement, with increased accessibility for members of the public, allotments or orchards which are referred to as green infrastructure study as being beneficial. Significant biodiversity net gain, 92% habitats, 71% increase in headwaters against the current position where there's only a legal requirement for a sort of photo finish improvement of effectively 0.1%. Economic benefits, which are agreed to have significant weight in sustainable travel and transport. Now, though Mr. Dawes disagreed with the weighting and categorisation, to which we'll return later on dealing with balance, he didn't disagree that any of these were benefits. We then turn to heritage, and we start with what we say really on analysis is a red herring of historic England's consultation responses. The council suggested and open repeated it a few moments ago. The great weight should be given to historic England's advisors, statutory consultation, and sort of elevate that to the point where there was some kind of test, legal test of cogent or compelling reasons necessary as a matter of law. So they suggest, just apart from historic England's stance, we say that's wrong in law. Particularly, it's wrong in law in circumstances where there's been an inquiry, where you have heard and tested contradictory expert evidence, and where historic England haven't attended to allow their own analysis to be tested in cross-examination. And we do rely on the judgment of Mr. Justice Holgate, who's the lead judge of the planning court, in the Newcastle case. He expressed doubt about the proposition, the terms set out there. I won't read the judgment because you've got plenty more to study them, but critically, you'll see in 74, he said, I had substantial reservations about this principle of great weight and a need for cogent planning reasons to depart, particularly in the case of the statutory review of planning appeals. This is my first then departure from the script. It's said by Ms. Sargent at paragraph 52 of her submissions, and I think also 53, the judgment of Mr. Justice Holgate as the lead judge of the planning court on this doesn't affect Wyatt, because Wyatt is called to appeal. That, with great respect to my early friend, overlooks the language used very carefully by Mr. Justice Holgate in his characteristic, careful way, particularly in the case of a statutory review of planning appeal decision. Wyatt was a judicial review of a local authority consent. And of course, generally speaking, when local authorities grant planning permission, they rely upon written representations, written evidence of the parties, maybe a 3-minute presentation by the key protagonists. The point Mr. Justice Holgate was making, the point that we reaffirm here, you say if I'm speaking too fast, is the analysis is different in the context of a planning appeal, certainly a planning inquiry appeal, where evidence has been heard, being tested in cross-examination, in the absence of this historic England. So Wyatt doesn't establish any proposition that applies to this particular context as opposed to the local authority's evaluation of written material that hasn't been tested. That's the point Mr. Justice Holgate makes in the last few words of paragraph 74 quoted there. So Wyatt, I'm afraid, it doesn't establish the broad proposition Ms. Sargent seeks to derive from it. Just let me complete your notes, sir, and then I'll return to the script.
Thank you very much, Mr. Bennett.
Thank you. So then we then rely upon the Journal of Planning and Environmental Law, which I think Mr. Grant, I'll pass you a copy. If not, I shall ask him to do so now.
I don't need to ask that this has been shared because of the comments that I had in closing. Thank you very much, Ms. Sargent.
The James Marici case, the distinguished silk, you may very well be familiar with, and another barrister have sought to review the authorities on this issue. And they refer to it, I'm sorry, that's a typo, I might have called the heart principle, not the hard principle. That is, all typos are my fault, not Mr. Grant's. That's an absolute. They refer to the principle as the heart principle. Because that part is one of the cases in the chain of case law. And I am going to dwell on the text actually here because it's important. But before I do, let me just say one thing. Obviously, Ms. Sargent said this is analysis by barristers. It's not legally binding. Well, obviously that's so. But we suggest it's a correct statement of the law. It's not suggested, I don't apprehend, it's suggested that Mr. Marici has overlooked some relevant case or failed to take any considerations into account. What this article does is pull together the case law and draw together some legal conclusions from it. We adopt them. It's not binding, it's right, and a court would follow it. So I just then want to dwell on what they say, that we weren't able to find an authority involving live competing expert witness evidence where the application of the Hart principle was in any way held to be decisive to inspector's assessment. This is unsurprising. And the planning inquiry is like a laboratory. Arguments must be placed under the microscope and tested, sometimes to breaking point. A statutory consultee puts forward his experts, an applicant appellant puts forward theirs, and that kind of environment's hard to see how the Hart principle can meaningfully be said to apply. The evidence put forward by a statutory consultee must surely attract such weight as it deserves, depending on how its witnesses perform, of course, if they bother to turn up, in all of the evidence as against the applicant's appellant's witnesses. It's a matter of judgment for the inspector. The question of which expert to prefer, where there's a contested technical issue, can't properly or sensibly influence by attaching more weight from the outset to the witnesses appearing from one party or the other. And then they go on to say, well, even if that's wrong, and it was said that the statutory consultee's views do carry weight to start with, it must be recognised that the inspector is perfectly entitled to reject that view where there's evidence to the contrary. They refer to a case supporting that proposition. They go on to say, therefore, that even if there is some bar for cogent or compelling reasons, it may not be that high. This is all the more so when the expert evidence that contradicts the views of the statutory, where there is expert evidence that contradicts the views of the statutory consultee. So where the statutory consultee objects in writing, doesn't pay an inquiry, this is our case, and the appellant applicant calls expert evidence expressing to contradict the views of the statutory consultee, that evidence would very readily provide a basis for departing from the views of the statutory consultee. So we endorse that. And we say, sir, that even if you were to agree with the council's incorrect legal analysis elevating historic England's position to some higher level against which we need to be cogent, compelling reasons, we say there are such reasons here in any event. And they are as follows. Firstly, the consultation response Historic England submitted, their first one manifestly strayed beyond its statutory remit into issues of balance, planning and housing, both the beginning and the end. And the response is unlawful as a result. There's a case from a couple of years ago, Swainsthorpe Parish Council, where Mrs. Justice Lang held that the statutory consultee's consultation response, in that case it was a Highways Authority's response, where they weighed in on planning matters, was unlawful and failed to be quashed because it went beyond the statutory consultee's remit. You've got that case, if it's an interesting read. Now, so too in this case, did Historic England stray. They strayed from providing objective advice on the effect of the development on heritage assets. They didn't just play where in the scale, they stepped into the arena and became an objector to the grant of planning permission. And that was inappropriately and unlawfully partisan. That is not their role. Their role is to provide evidence and advice on effect, not to push for an outcome. And that is what they did, unlawfully and inappropriately. And although they submitted a later response, that later response doesn't withdraw the first. The two are on their face, intended to be read in conjunction with each other. So the flawed first response still stands. I just add here as well, sir, paragraph 57.1 of my learned friend's closing refers to a discussion she had with Miss Stoughton in cross-examination about this. But ultimately, the proper reading of Historic England's advice falls to be turns upon the document itself. It says what it says, and what it says is unlawful. So that's the first reason. These are all, I should add, these are all freestanding reasons. I don't need to make good each one of these reasons to make good my case on cogent compelling reasons. The second point is at B. And B is that the council's own expert, Dr. Hickey, departed from the advice historically. This isn't a case where they're and saying we agree with everything Historic England said. They too accept that there are cogent and compelling reasons for taking a different view to Historic England on heritage matters in this case. Thirdly, both Ms Stoughton and Dr Hickey have appeared before you to have their evidence tested in cross-examination. Historic England nowhere to be seen. And evidence subject to cross-examination can be considered more reliable and worthy of more weight than it's not. That is a long-established principle. I venture to suggest a principle you've applied in your 18 years as a planning inspector, sir. There's no doubt about that principle whatsoever. Fourthly, there's no indication that Historic England visited the site at all. Both Ms Stoughton and Dr Hickey accepted and stated that was an important part of informing any assessment. And fifth and finally, for the reasons Ms Stoughton outlined, Historic England's analysis is, on a proper view, inconsistent with their previous scoping advice the Regency gave in her proof. So to the extent you need cogent and compelling reasons to part from Historic England's analysis, you have them. The Conservation Officer's response to this application can be similarly I say disregard as perhaps an unfortunate choice of words on my part. It's unconvincing. It's civilly unconvincing. You have to have regard to it, but reject it. It's just over 2 pages. It's simplistic in its analysis. It's unduly swayed by Historic England. And it's out of line with both Dr Hickey's and Ms Stoughton's analysis. That officer too hasn't appeared in the inquiry to have their analysis tested. So we suggest really the focus should be on the competing evidence of the witnesses who you've heard all evidence in the inquiry and who's had their evidence tested, namely Ms Stoughton and Dr Hickey. So turning then to the battle of the experts who did turn up to the inquiry, we start with issues of methodology and approach. And we submit you can have no faith at all in Dr Hickey's methodology. It was so flawed, we take the unusual step of submitting that reliance on it would be unlawful for the reasons that follow. And of course, I just add here, of course, Dr Hickey accepted it was essential methodology. My own friend in her closing sought to say, well, the methodologies didn't really matter because you'll form your own judgments. Dr Hickey accepted the methodology was essential to his analysis. That was a very clear acceptance. And he also accepted that this essential methodology was unofficial and untested. It was based on ICOMOS and the British standard methodologies that don't purport to and do not provide guidance on assessing harm for MPPF purposes. Secondly, he accepted that the methodology leaves the double counting of the asset's importance in the decision-making process. And I've been through that already. The reason for that is that he takes into account as a multiplier to magnitude of impact the importance of the asset, whether it's grade 1, 2-star, etc. But the importance of the asset is relevant not to the where within the scale of harm, the purposes of paragraphs of the framework that deal with heritage, not relevant to where within the scale of harm the effect of endowment lies. It's relevant to the weight to be given to that harm under 199 Reg 102, 202. Under Dr Hickey's approach, it's both. And that's why it'd be unlawful. Because contrary to what Ms Sargent says in closing, this is 48.2 of her submissions, contrary to what she says, the NPPF does not mandate this. This is not about taking into account the significance of the asset. This is about taking into account the importance of the asset. That's the importance of the asset which Dr Hickey's table takes into account as a multiplier of impact to generate level of harm, and then the importance of assets taken into account twice. And it's unquestionable that any judge in the High Court would say a double counting methodology which is not expressly required is unlawful. And thirdly, turning to set Dr Hickey's approach also is demonstrably inconsistent with the framework, as he accepted explicitly in cross-examination, because it precluded a finding of substantial harm to grade 2 listed building. That itself ought to raise a very serious red flag, I'd suggest, for you, sir. That's a helpful paradigm illustration of how the matrix approach simply doesn't work in this context, as Ms Stone elaborated. Now, In answer to your question, re-examination, he attempted retrospectively to bolster this obvious erroneous methodology through adding an additional column. That was entirely unconvincing. Dr. Hickey clearly did not revisit his whole assessment. There's no chance to cross-examine him on it. And Ms. Stoughton showed it didn't work. And Dr. Hickey also accepted, and as Dr. Hickey also accepted cross-examination that his methodology was an essential component of analysis, it does call into question each of his judgments. It's important also to note, as I said at the outset, that he also went on to accept that if one strips away the double counting and only has regard to magnitude of impact, his ascription level of harm is not very far off where Ms. Stoughton lands. He still thinks there's some harm to the church, but not very much. And that's a useful sense check, actually. Turning then to paragraph 28, there was some suggestion in cross-examination Ms. Stoughton repeated in paragraph 48 of my learned friend's closing. And Ms. Stoughton too looked at the importance of a heritage asset in forming her view, did the same as Dr. Hickey, and that was advanced as a sort of defence of the Hickey methodology. But let's be very clear about this, she didn't. What Ms. Stoughton did is look at the contributors to significance. What were the things that contributed to significance, pulled together in that the tabular approach that you see at the end of each section of her proof, and how proportionally the contributors to significance are affected by the development. That is not the same thing as saying that harm to a particular type of asset, grade 1, grade 2, must always be above or below a certain amount of harm because it's harm to that grade 1 or 2 asset. That is multiplying harm by importance before it being then in fact weighed against importance again. Dr. Hickey made that mistake, Ms. Stoughton did not. And so, other than the methodological issues, there are further reasons to be concerned about Dr. Hickey's professional judgment of this case, and they are as follows. Firstly, he'll take 1 4-hour site visit with both his heritage and landscape hats, and he accepted, he formed a view about the surroundings in which the heritage assets were experienced without visiting all those surroundings, and even declined a joint site visit with Ms. Stoughton. And his exception, again, repeating and closing this was perfectly admissible, was because he was an experienced professional. Rings hollow in the face of the shortcomings of methodology. No matter what one's experience generally, you need to see a site. We also, of course, noted that he took on the instructions, accepted the instructions to defend the appeal before seeing the site. Secondly, he seemed unfamiliar with any historical source material, having stated in cross-examination that he relied on Ms. Stoughton's historical research. To take one example, he failed to register that an orchard is marked on the tithe map for Middle Farmhouse, before then attempting to dismiss it as garden, which plainly was unmeritorious because gardens are separately marked on that tithe map. And then he suggested it wasn't a commercial orchard, which is irrelevant because no commercial orchard is proposed. He then suggested the historical mapping wasn't really relevant. Well, for the reason Ms. Stoughton said out, that simply doesn't work. An understanding of the development of an asset and its historic associations is plainly part of the understanding of the way it has been and may be experienced. Thirdly, and notwithstanding that inexcusable dismissal of historic evidence, Dr. Hickey was reliant on those setting maps, the blue areas, a concept which Ms. Stoughton hadn't seen in the 50 to 100 inquiries that she has been involved in. These settings maps don't give any indication of what contributes positively or negatively to significance. Dr. Hickey said that they aren't endorsed by any official body or document, and they seem to have been the product of a simplistic methodology, drawing lines between fields which are and aren't part of the setting based on distance, rather than complex matters such as patterns of land use, ownership, experience, and connections to the past. Indeed, the very problem with the tables was illustrated by Ms. Sargent's cross-examination of Stoughton when she suggested that it couldn't be cross-examined based on, also say, 80% of an asset setting. That's not the issue. The issue is not the percentage loss of a setting. The issue is loss of significance. And these plans elide those two importantly separate questions. Fourthly, Dr. Hickey had some unfortunate lapses of memory during the inquiry, forgetting first, for example, that he hadn't in fact taken the photo exhibited in Figure 4, which he certainly had until it suggested he hadn't, and forgetting also, again, to have suggested that he hadn't, that he'd been offered as joint site by Ms. Stoughton. Fifthly, and in contrast to those lapses of memory, Dr. Hickey seemed able to form judgments on how, for example, the adjacent garage office building fits into the setting of the church, notwithstanding it's only half completed. Sixthly, whether it was through lapses of memory or something else, Dr. Hickey's evidence was inconsistent between chief and cross-examination. In chief, he indicated that the harm to the conservation area was at the low end of less than substantial harm. When asked in cross-examination if the harm was at the low, not lowest end, he said no. So there was some confusion there in his evidence. Seventhly, Dr. Hickey's judgments of harm departed from the council's statement of case in 3 respects, and his levels of less substantial harm then required reworking orally as he failed to apply his own methodology. We'll call that in chief, where he had to confirm changes to his description of harm. The council's case is therefore, we say with great respect, unsupported by any remotely credible evidence. Nothing detracts from the careful, considered analysis for you by Miss Stone, performed after 5 to 6 site visits and a deep dive into the history of each asset. There are 5 assets in issue that designated as the church, the Middle Farmhouse, Stocks Farmhouse, the conservation area, and then there's the non-designated assets. Following some corrections by Dr. Hickey, there's now agreement by Dr. Hickey and Ms. Stone on 2 low levels of less than substantial harm to the conservation area, Middle Farmhouse, and to the extent that you might weigh them separately, the non-designated assets. And further and importantly, as I've noted at the outset, Mr. Dawes accepted that for the purposes of paragraph 202, the differences between the experts were not meaningful, and either's could be on those matters I've mentioned, that either's conclusions, any harm to these heritage assets would be outweighed by the scheme's public benefits. And he accepted explicitly, wasn't re-examined on the point, this point isn't returned to by the council's closing, that the only differences between the heritage assets that have mattered relate to the church and Stocks Farmhouse. That does appear to be now common ground. That's really the crunch for use in relation to heritage. And so, for obvious reasons, we focus on those 2 assets going forward. So we turn first to St. James's Church. Miss Stoughton says no harm. Dr. Hickey says mid, but only mind if you don't double count. And Dr. Hickey, in terms of where within the scale of the harm lies, we start by noting that Dr. Hickey agreed with each of the 5 contributors to significance that Stone set out in that table and putting together her narrative approach. And he agreed there was no harm to any of those contributors, including the primary contributor. His sole point of disagreement in relation to the church was that Miss Stone should have had a further 6th contributing factor in the form of the fields, the north and western fields, and as a result, mid-level harm. And that analysis, we say, doesn't withstand scrutiny. And in particular, firstly, as Miss Stone outlined in chief, historic England's guidance is very clear that simply being able to see a church from the wider landscape isn't enough. There must be a contribution to significance resulting from that view. Or as part of that view, see also page 33 of Miss Stone's proof, which, having set out that guidance, reinforces that proposition by reference to some Secretary of State appeal decisions. And Dr. Hickey agreed with the proposition in cross-examination. As Miss Stone pointed out in chief, there are cases where wide surrounds fields contribute to the setting of a church. For example, where it's an isolated spot between multiple settlements, but this is not one of them. And whilst one could just about see the church from Bender Park away, that doesn't contribute to the significance of the church, because there's nothing informing an onlooker of the heritage significance of the church in the setting. One can't understand the interface between the immediate surrounds of the church and the area one sees. Now, though there will be some views of the church at the site, they are not illustrative of any aspect of the church's heritage significance. You can't discern clearly the architectural interest of the church or appreciate the historic context of the church in relation to the rest of its settlement. Stone's proof and plate 20 show this. The tower may be conflated with the body of other buildings, such as the schoolhouse, whilst the rest of the settlement is obscured by trees and vegetation. Even in winter, there's a clear distinction in this respect between views from the site and, for example, views from the fields lie between the church and the site, to which the conservation appraisal refers. Further, while some land to the north of the site was in the ownership and occupation of the rector of the parish, that connection, it's agreed, but Dr. Hickey is no longer legible, and the site lies outside that area of land. The former ownership of the site by the Brockers estate has long since ceased, isn't legible as landscape today. Again, Dr. Hickey agreed that, as he agreed that the site was tenanted out of the Brockers estate, unlike some of its land. Dr. Hickey's analysis was based upon these fields being a more important contributor to the significance of the church than the settlement of the church serves. He said that in all evidence. That's obviously a fallacious analysis. Even if you were to consider the fields to be a contributor to significance, the suggestion one gets to mid-level, less than substantial harm, by virtue of harm to one contributing factor out of 6, when the primary contributions to significance are not effect, lacks any credibility. And relying on relative weightings of the contributing factors not enough is agreed. There's no harm to the primary contributor, the built fabric of the church and the immediate churchyard. So for those reasons, we say there's nothing that substantially detracts from Miss Stoke's analysis in relation to the church. We submit she's right to say there is no harm. And even if we're wrong, even if she's wrong, at the very most, it's less than substantial harm at the lowest end of the spectrum. So now we turn to Stocks farmhouse. And Miss Stoughton's view in that respect is there is some harm, less substantial at the low end of the scale. Dr. Hickey says upper end, based on his essential double counting methodology, it must be remembered. And medium if it's simply a question of measuring impacts and not double counting importance and value. Now, again, in cross-examination, Dr. Hickey agreed that Miss Stoughton's table in her proof relating to stocks contained a complete and accurate list of the contributors to significance on which there are 4. He agreed the primary contributor to the significance is the fabric of the building, and that there is no harm to the first 3 contributors to significance: fabric, associated garden and driveway, and formerly associated farm buildings. So the dividing line is whether the 4th agreed contributor, the wider surrounds of the historically associated farmland, provide a greater contribution and suffer greater harm than that suggested by Ms. Stone, so as to justify the higher description of harm that Dr. Hickey gives. Now, in terms of the contribution of each of those factors, Dr. Hickey suggests that the agricultural land is equally important to the formerly associated farm buildings and more important than the associated drive and garden. Miss Sargent went actually further in cross-examination, suggesting to Miss Stone that the character of the agricultural land was in fact more important than the formerly associated farm buildings because the change in use of those buildings reduces their importance to the contributor significance. Now, neither of these approaches are justified. We make the following points. Firstly, a point made by Dr. Hickey and pushed by Miss Sargent is the cessation of the functional use between the farmhouse and the outbuildings. Functional links between those buildings. Now, as Ms. Stoughton explained, however, the cessation of their agricultural use and the links between them indicates that the contribution of the setting as a whole makes a lesser contribution to the significance of Stocks farmhouse than it did before. Had we been looking at this whilst it was still an active farm, there would, for example, be movement patterns between the farmhouse and the fields, the farmhouse and the farm buildings, which would reinforce and be readable as reinforcing the historic illustrative value contribution. But that is no longer so. It does not follow, however, that the severance enhances the relative contribution of the agricultural land. It is a reduction in historic illustrative value of the setting as a whole. And when raising the relative contribution of the setting, the following factors apply. Firstly, the garden plot is where the asset can be best appreciated. The farmhouse's primary facade faces its former driveway and the road beyond, and the farmhouse's primary facade faces its former driveway and the road beyond, and its secondary facade faces the garden to the south. This is clear from the historic mapping, the former locations of the entranceway, the facades, and the regularity inside the windows, all of which are set out in Miss Stone's proof of the various illustrations there. By contrast, there have historically been outbuildings between the farmhouse and the agricultural land, now to be occupied by the site, albeit one of those outbuildings has been absorbed into the asset. There's no design views between the farmhouse and the site, and that again appears to be common ground between the experts. The farm buildings still retain their historic illustrative value for the farmhouse. They're still legible as farm buildings historically linked to the farmhouse. It may not be a farmhouse now, they may not be farm buildings now, but it reads still as a former farmhouse surrounded by former farm buildings. By contrast, the historic connection between the fields and the farmhouse is now only legible through consulting the historic maps. If you look at Miss Stone's plate 62, it's clear that now standing between the farmhouse and the fields on which Dr. Hickey places such high significance is a strip of now sizable domestic garden, the wider area of which contains a swimming pool and a tennis court. There's no clear, readable link indicating where the functional link might once have been. And fundamentally, the legibility of the farmhouse as a farmhouse or former farmhouse is not contingent on the link with the historic farmland. We ask you to test it this way, in the way that was discussed in evidence. If you were to take away all the agricultural land tomorrow, the farmhouse would still be legible as a historic farmhouse because of its fabric, the former farm buildings and the granary. The fact that you would perceive a former farmhouse would not change. Now, Dr. Hickey suggested the resultant harm to significance would be 8 out of 10 on a scale where substantial harm, such as, albeit not limited to depriving the building significance, but that would be the 10 out of 10, the very top. That's plainly an exaggeration, whether one uses the logarithmic scale or not. The wider agricultural land is not a significant contributing factor to reasons outlined above. The other 3 factors contribute more and are agreed not to be harmed. 3 out of 4 factors are not harmed in any way. The level of harm Dr. Hickey ascribes to this single remaining contributor is overblown, bearing in mind the sensitive design of the scheme, the green corridors and the offsetting of the houses. Fundamentally, once all the houses are built, Stocks Farm will still be legible as a farmhouse due to its fabric, due to the garden plot and driveway from which the assets can better be appreciated, due to the formerly associated farm buildings, such as the stable blocks within its curtilage, the converted farm buildings to the north, and the granary across the road. Still be readable as a former farmhouse. There will be some harm, and we accept that. We always have. But the crucial factor is the farmhouse will still be legible as a farmhouse. Turning then to landscape and visual effect. This issue, we suggest, must be kept into perspective. It's agreed that any greenfield development would have some localised landscape harm, and that any landscape and visual effects of the proposals would be mainly focused on the Peel site and its immediate locality, a stretch of well-contained, ordinary countryside within a landscape which is not designated, not valued in NPPF terms, and isn't even recorded as a local green space and neighbourhood plan, which does identify the landscape, the raw landscapes that matter, as we saw on page 50. Of course, there are differences in the judgments between Dr. Hickey and Mr. Smith, and you also will have to form your view. We suggest that Mr. Smith is a far, far more reliable witness than Dr. Hickey where the following apply. Firstly, Dr. Hickey admitted in cross-examination that he accepted the instructions to defend the decision without visiting the site. Before accepting in cross-examination the site was an important part of your determination. Mr. Smith, by contrast, has been active in designing the scheme and in reducing the number of units in order to ensure it was indeed landscape-led, as it is. When Dr. Hickey did visit the site, as noted already, it was for 1 4-hour visit, during which he had to assess it both for landscape and for heritage purposes, whereas Mr. Smith visited the site no less than 3 times and wears only 1 hat. Dr. Hickey selectively quoted and materially omitted relevant passages from the Council's own 1-year-old evidence base, the HDA material, which ran against his analysis. And when pressed in cross-examination, he provided no convincing justification for so doing and admitted they were relevant evidence. And whilst he deprecated any suggested evidence to be misleading, it is a far cry from the straight back with which Mr. Smith has approached matters. Dr. Hickey is, by his own admission, an outlier in relation to analysing these issues, whereas Mr. Smith's judgments are reasonably similar to the other expert documents before you, such as the HDA work. Dr. Hickey criticised the methodology employed in these other documents without basis, without contacting them, or even attempting to contact them. And most importantly, his judgments didn't survive the smell test, and we'll come back to that in a moment. His landscape work is predicated in part on the validity of his heritage assessment. See, in particular, section 6 of his landscape proof, and for the reasons we've outlined, his heritage assessment is not reliable. We then turn to character. We start with the value of the landscape. Mr. Smith is right in this respect. The reasons set out in his proof. He properly applied technical guidance note 221, of which he was co-author, considering each factor in the basket of 9 relevant factors to come to a reasoned conclusion on value. And in cross-examination, he dealt with the sole criticism made by the council in this respect, that he somehow failed to apply the TGN that he co-authored properly by not considering parts of the site as settings for heritage assets. There's nothing in that point. He explained why the landscape to the south, adjacent to the conservation area, has an identifiable cultural heritage landscape value, while the remainder of the site's landscape does not. It's not that he didn't consider assets such as Stocks Farmhouse, he simply did not judge with the same degree of landscape association with the setting of that building. Dr. Hickey, by contrast, appears first to have made his landscape value parasitic on his heritage assessment, which we already discussed, and secondly, focused solely on cultural heritage value, and not the remainder of the remaining 8 factors in the basket of factors relevant to value that TGN makes clear should be considered. See Table 1 therein. The difficulty of Dr. Hickey's approach is evidenced by his candid acceptance cross-examination that he struggled to understand how a landscape can be of local authority level, in his case, and not a valued landscape, an inherent tension in his analysis. Turning then to the baseline, nothing you heard from Dr. Hickey or in the cross-examination of Mr. Smith detracts from the detailed assessments that Mr. Smith has undertaken and the author of the LVIA has undertaken. There's no dispute about the appropriateness of the receptors used. Mr. Smith has undertaken a subtle and nuanced analysis looking at the landscape's individual elements, whereas Dr. Hickey simply looked at the site as a whole, broad brush approach, notwithstanding the fact that he accepted in cross-examination the landscape character is not the same across the site. His suggestion that undertaking an element-by-element analysis, as I called it in cross-examination, might in any way be misleading is baseless. What his approach does is a simplistic analysis looking at the site as a whole without its individual components, which even he accepted lacks nuance. And the fundamental starting point we suggest is, as Mr. Smith contended, there is a gradient of character across the site. The western edge is almost entirely rural, but the eastern side has a clear sense of being on the settlement edge. Mr. Smith's plates demonstrate this, we suggest, and we trust you will have seen this on the site. Now, the eastern side does have the capacity to accommodate some development, and that is backed up by HDA's landscape character assessment and accompanying landscape sensitivity study, the latter of which is precautionary relative to this application because it assesses a 60% built form, whereas the appeal scheme is 24%. That's 100 minus 76 by my dodgy maths, compared to the 76%, which is open space. It's ordinary countryside, a term used by Dr. Hickey and accepted by him, with medium sensitivity to accommodate some development. The suggestion by Dr. Hickey that there is no ability to accommodate development, his words confirmed in cross-examination, is outlandish, and you only have to have heard his answer in cross-examination, dismissing the pylons and built forms already present as small dots to be able accurately to gauge its credibility. As to what the effects are, they're set out for each receptor in Mr. Smith's tables D3 and 4. He is very clear and convincing that there will be major, moderate landscape harm to 2 receptors on the eastern part of the site, but in other respects, in all other respects, the other receptors will be safeguarded. Overall, large portions of the sites will remain rural in character. The fact that there will be some landscape harm is inherent in any greenfield development, and that is agreed. Within the site, the effects are limited to the eastern part, and the effects here are not solely negative because there will be elements of betterment arising from the creation of a very substantial new open space exceptional both in its quantity and its quality in the planting of new hedgerows, providing we suggest a better settlement hedge than is present. Dr. Hickey's concerns that the open spaces would read as suburban green space, term he used interchangeably with other similar descriptions, those concerns are misplaced. In fact, this was a fundamental mischaracterisation. The suggestion seemed to be that any change from agricultural land managed by farmers is deleterious. And that is obviously oversimplistic and misconceived. Dr. Hickey's evidence on this point got confused, initially appearing to distinguish between a country park, which he saw was managed, and agricultural land, which he saw was not managed, which obviously it is, before then suggesting that agricultural land would be natural habitat if it stopped being used as agricultural land. Though there was no suggestion this would be the case here. Before then suggesting agricultural land is open countryside and meadow is somehow not. Now, this analysis was confused and confusing. We expect and would invite you to reject it. Mr. Smith's and Miss Stoughton's references to other illustrations of meadows and other similar kinds of green spaces which had a rural character, and not just rural character, but which were cherished by the communities that used them. Those references provided, by contrast, well-informed and convincing evidence that the open space of the appeal scheme would perform similarly. And you'll remember Mr. Smith's plates that evidence that, and Miss Stoughton's reference to Bradley Green. Looking beyond the site, any change is highly localised. Although Dr. Hickey suggests that landscape change extends beyond the site boundaries, it can only offer some amorphous idea of a localised effect, perhaps over a few hundred yards, perhaps a street. Frankly, if you need greenfield development to meet a pressing need, it would be hard to imagine a settlement with more contained effects than this. So on landscape effects, we end up where we started. There will be some negative effects, we accept that, but there will be betterment too. The meadows, the reinstated hedgerows, orchards, and net gain. Any negative effects are highly localised, barely stretching beyond the site, and frankly not even covering the entirety of the site itself or anything like that. In terms of visual effects, the site is extremely well contained visually, as Mr. Smith precautionary ZTVs show. The agreed crop of representative viewpoints is, as Mr. Smith outlined, unusually focused. And Mr. Smith's tables, E1 to 3, walk you through the changes. It's a very fair, candid assessment. At year 5, there are major moderate negative effects to 3 viewpoints. By year 15, which is agreed as the relevant litmus test, that's reduced to only 1, viewpoint 3. But viewpoint 3 is the low point, if you like, or the high, or conversely, the high watermark of the objection, the worst. And yet Mr. Smith outlined even that viewpoint has some positives. In design terms, it's a successful settlement edge. More so, we suggest, than is currently there.
Found this on the web.
Sorry, how that's happening.
It's always nice to be endorsed by Siri. It has filtered views of watches and protection of filtered views of watches, filtered views of houses, and protection of border countryside through lots of planting. Overall, we commend Mr. Smith's view that the scheme's visual impact is minimised and reflects and complements the various views set out in the neighbourhood plan. A point was taken in cross-examination against him that other appeal decisions did not concern sites with public rights of way on 3 sides. But actually, that's factually not right. Oakley, for example, Station Road, have public rights of way on 4 sides, as the decision shows. To the extent that you have regard to Dr. Hickey's analysis, despite its shortcomings, it doesn't in any way detract from Mr. Smith's. Frankly, his judgments don't pass the smell test, and one can view it this way, that he concludes that the changes to viewpoint 10 at year 15 is the second highest level of impact possible. You recall that dialogue. And when you come to write your decision, we ask you to turn that photo montage up and look at it again and think, is that really credible? Second highest level, second one rung down from building all over that land. And ditto viewpoint 4, the third rung down. We won't make detailed submissions what you can and can't see in the pictures, you will judge it, but we suggest that Dr. Hickey's judgments are absurd, and there's clearly been no sense check at all by him of those judgments. Turning then to drainage, relatively short on this, not least because we dealt with yesterday, and you have a statement of common ground. It's not in dispute that foul drainage, an opportunity between the main parties, can be resolved by condition. The issue is the particular wording of condition, and in particular now I can slightly depart from the script. It's the revised condition B handed up today versus the council's C, there being agreement that the Thames Water condition A isn't quite right. Now, conditions, of course, have to be necessary to make development acceptable. And local authorities have to substantiate their reasons for refusal. And with that in mind, we say it's for the council to provide evidence as to why a potential, for it is only that, temporary contingency option for the first 50 units, such as, not necessarily, but such as Tanqueray, is incapable of being acceptable in planning terms, so as to justify a condition which definitively rules it out now. They simply haven't done that. There's no evidential basis to rule out now, once and for all, a potential temporary contingency option such as tankering in the relevant condition. The evidence of Mr. Brackley has demonstrated it's feasible and acceptable in engineering terms, and the evidence of Mr. Bevis has shown it would be acceptable in highways terms. Now, despite that, our proposed form of condition would not rule in tankering. It would simply allow the case to be made and reviewed and scrutinised and the decision made on it in due course in the unlikely event that it should be necessary. And then I'm going to hand over to Mr. Grant to deal with traffic, transport and third-party matters, and I'll resume at the end on balance. Over to you, Mr. Grant.
So on traffic and transport generally, there's no dispute that reasons for and five have fallen away following a careful and considerate transport assessment and, of course, the two transport assessment addenda. The Highway Authority has made the appellant work for it, and model scenarios on bases which, as Mr. Bevis explained in chief, he considered are worse than precautionary, but they are now content that there are no traffic impacts justifying refusal. Mr. Bevis has also taken you through, both in writing and in chief, his assessment of matters and the basis on which he concludes the policy tests set out in NPPF Para 110 and local policy are met. In the absence of countervailing expert evidence, we encourage you to adopt that analysis, though we don't see any use in repeating it all in this closing. To address some of the criticisms made by third parties, the effects on and of the level crossing is clearly a contentious issue. But in terms of the baseline, it's been thoroughly assessed by Mr. Bevis and his team, measuring closures rather than train movements. It is not for this development to have to compensate for any pre-existing issues to the extent that there are any. The key point so far as this application is concerned is that Bramley is and will remain a sustainable settlement, and the traffic impacts will add no more than 2 vehicles on any approach, increase dispersal times by at most 7 seconds, and will not add to junction blocking or queue dispersal issues. That's the position on the ground now, and this development should not be refused because of uncertain predictions about train usage going forward into the 2030s and 2040s. If anything, our development helps with sustainability because there may be a shot on the western side of the railway. As to whether the bus will continue to be viable, this isn't really an issue for the development. It exists now. If more people use it, because there are 140 additional homes, then the case for its retention remains. If they do not use it because the railway is more competitive and convenient, this does not undermine the notion that Bramley is a sustainable settlement because the train, in favour of public transport, still works. As for the safety of the junction speeding on the roads, Mr. Bevis has candidly accepted that cars speed above 30 miles per hour. As you said, sir, it's somewhat rare for the traffic expert to accept that, but he's been very clear about it. It's unfortunate and it's illegal, but the access to the site has been designed safely, and to the extent there is any effect on speeding, it will reduce the likelihood of speeding because of cars coming and going from that junction. Third-party concerns, other third-party concerns, have been addressed through the evidence of both Mr. Ross and, again, to an extent, through Mr. Bevis. The third parties who've spoken during this inquiry have repeated the theme that this will be the score which breaks the planet's back. The Bramley cannot support any homes, and we say that's simply not right. It's not always taken by the council. It is the case that Bramley, 1, is sustainable and does have capacity for more homes, see Mr. Bevis's response to the questions posed by yourself and third parties. And 2, the scale of the development is both proportionate to other neighbourhoods in Bramley and is a logical extension of the settlement. That's more discussed with Mr. Burton. A further concern that Mr. Ross addressed orally is whether the settlement would accord with the vision for the neighbourhood plan. Again, we won't repeat his step-by-step analysis, but submit it shows that it very much does. Councillor Durrant suggested there's no need for development outside the settlement boundary, and again said this isn't the council's position, as for reasons we've explored at length is simply wrong. As Mr. Ross further explained, you could not even deliver the infrastructure source in the neighbourhood plan within the settlement boundary, at least as far as the neighbourhood plan identifies it. I'll hand back to Mr. Bannon.
Thank you. So before I deal with the overall balance, I want to just touch upon reason 7 and what's said on page 26 of the council's closings, paragraph 61, where it said in the event that the public right-of-way contribution isn't effective, to remove the use that's put, the council maintains reason for refusal 7. Now you'll see the final form of the obligation in due course, but the intention is not to remove anything from the unilateral. You will be given in the usual way effectively a choice with what's known as the regulation 122 boilerplate clause. We find it hard to see how the council can adopt the analysis it does, because if you think what they want is necessary to make the development acceptable, then you will so indicate. If you decide it's not necessary to make the development acceptable, then they've got no legs to stand on in terms of advancing a reason for refusal. We don't accept the characterisation in terms of this being used to county council, but I'm not going to say anything more about that because it doesn't really go anywhere. I then turn back to page 33 of the closing, section 9, with accordance with the development plan. We endorse Mr. Ross's detailed analysis of each relevant development plan policy and the extent to which the appeal scheme does or doesn't accord with it. You don't have that same level of analysis in Mr. Dawes' proof. It's common ground that policies SS6 and H1 are at least partially breached, but that the weight to be given to that breach is limited and not enough either to refuse the application or even on its own to justify a conclusion of non-accordance with the plan as a whole. As for H2 of the neighbourhood plan, Mr. Dawes considered that this policy should be of limited weight. But as Mr. Ross explained, we consider the way around, because in our judgment, that policy supports the development given the current affordable housing crisis in Bramley, the identified need of 102 and the British appeal scheme, and as such, it should be given full weight. Then dealing with the basket of policies referred to in paragraph 69 that bear upon the council's principal case, EM 1, 10, 11 and neighbourhood plan D1, it's common ground they should get full weight, and they are the meat of the matter so far as the plan goes and accordance goes. It's also common ground these aren't zero harm policies, and they can accommodate a degree of new greenfield development and the harm to go with that without being breached. Indeed, they're capable of accommodating even quite a large greenfield allocated site. See, for example, the Oakley illustration, which was 110 greenfield allocated homes found are expected to be in accordance with the M1 and the M10. There are obviously limits, and Mr. Ross very fairly accepted that if you agree with Dr. Hickey, then that would go beyond the policy tolerances in terms of harm. However, Mr. Dawes accepted, and he cannot sensibly suggest otherwise, that EM11, in terms of its application, even though it doesn't in its terms talk about public benefits, in terms of application, should have the same outcome as paragraph 202. And I do want to say a few words here because therefore accordance with the development plan in relation to heritage, which basically means EM11 and D1, accordance with the development plan as a whole doesn't simply turn upon where the level of harm lies in your judgment. And there seemed to be a suggestion of that by Ms. Sargent in her closing. That cannot be right. It cannot be right because it's common ground and was established by the inspector in the Oakley case that, as I said, the application of development plan policy in relation to heritage should, consistently with the framework, have regard to the balance set out in 202. So ultimately, consideration of accordance with the plan in relation to heritage, as per 202, requires to be informed not just by assessment of harm, but assessment by whether that harm is outweighed by public benefits. And I'll give you the references as that may be important to the overall analysis. It's CD 4.1 is Oakley, paragraphs 51, 93 and 103, 51, 93 and 103, which I took Mr. Dawes to in cross-examination, with which he expressed agreement. CD 4.1, 53, 93 and 103. So I turn it back to paragraph 66, and Mr. Dawes in chief identified relatively limited ways in which he says the development doesn't comply with subparts of these policies, principally M1, C and D, M10, 2C, M11, A and C, and D1, A, D and E. But for the reasons we outlined, any harms fall in relation to the landscape within the degree of tolerance of these policies related to heritage, the balance is struck in our favour. In terms of benefit, we submit that the various benefits of the scheme should be given the weightings Mr. Ross has ascribed them in his table. As for Mr. Dawes' analysis, firstly, his suggested provision of 440 homes should be given only considerable weight, run 2 on his scale, is unconvincing in circumstances where there's a clear and worsening shortfall of what we say is decisively below 4 years. This benefit should, we say, be given the greatest weight possible, consistently with other appeal decisions outlined in Mr. Ross's proof and appendices. Although Mr. Dawes gives affordable housing as benefit less weight than market housing, he accepted this was a fairly unusual approach. We suggest that's a bit of a euphemism, which is based on the council's view that the affordable housing shortfall is not significant. And he agreed that if you disagree with that, consider the shortfall is significant, then affordable housing should be upscaled to the highest level of weight on his scale, substantial. And we say on any tenable view, both district-wide and in Bramley, the unmet need for affordable housing is plainly significant, justifying that upscaling. Mr. Dawes was wrong to aggregate several of the other benefits when each of them was of freestanding importance. His approach of giving them a collective weighting rather than individual weightings had the effect of underplaying the planning balance. Each benefit secured by either development itself or through the unilateral undertaking is a weight in its own right and should be considered individually. And we do not, finally, we do not accept Mr. Dawes' downgrading of the weight to some of the benefits for which there is an established need identified in the local plan. He accepted that was inconsistent with his own approach to affordable housing, because of course affordable housing is also so required. It doesn't make sense either. They're development plan requirements precisely because they're of benefit. So turning to paragraph 202. Mr. Dawes accepted in cross-examination it is now common ground that if you would agree with Ms. Stoughton's evidence, the paragraph 202 balance comes down in the appellant's favour, and the reason we've outlined her analysis is to be preferred. In any event, Dr. Hickey's evidence on level of harm is plainly exaggerated and reliant upon his obviously flawed double-counting methodology. Even though, if you were to go so far as to accept Dr. Hickey's analysis, applying his own double-counting methodology, the heritage balance still falls in our favour, as Mr. Ross outlined in his oral evidence. The significant benefits of development, not least in meeting the desperate housing need, outweigh the harm. Mr. Ross isn't out on a limb on that analysis. The council itself has recognised that the serious unmet need for both affordable and market housing is capable of outweighing less substantial harm, not just generally, but in Bramley, and not just in Bramley, but in relation to Stocks Farmhouse. See the St James's Park. So we therefore say that paragraph 202 comes down in our favour, and there's no reason to disapply the tilted balance. Obviously, if we're wrong, if we lose on 202, that's it. We don't get the tilted balance. That's obvious. But if we do, then everything else falls to be considered within the complex of paragraph 11D 2. And applying 11D tilted balance to the remaining issues, everything other than designated heritage assets, such adverse impacts as the development would cause plainly wouldn't, we say, significantly and demonstrably outweigh the many benefits. There will, of course, be some harm, as we've said all along. But as Mr. Dawes accepted, the unmet market and affordable housing need has to be met somewhere, and this can't be done without some harm being accepted, without some compromise having to be made. Here, the harms are limited and the benefits are substantial. So, pulling all of that together, we say the following. First, the appeal scheme is a cause for Birmingham as a whole. Secondly, the paragraph 202 balance does not provide a reason to disapply that. The harm is very limited for the reason we've given. The public benefits, whatever the level of harm, outweigh it. Thirdly, even if you find there is some non-accordance with the plan as a whole, the tilted balance is engaged post 202, and post 202, within the tilted balance, that balance falls firmly in favour of granting permission. The adverse impacts do not significantly outweigh the benefits. So whichever way you look at it, sir, we invite you to allow the appeal. That is the closing submission, unless you have any questions. Thank you.
Mr. Banner, thank you very much indeed. I am going to ask a quick question.
Sure.
It's your para 71.
71, yes.
Applying tilted balance to the remaining issues, i.e. everything other than heritage assets. Thought there was agreement that it was the balance was all of the harms come forward beyond 202.
So yes, what we mean by
I
that
just
is-
misread.
Yeah, so what we mean is in 202 is just heritage versus benefits, whereas once you go through that, the tilted balance is then the next stage. That's all we so it's the second stage after 202. So that's probably clumsy language on my part. Yes, that's probably clumsy. Yes, because it's still relevant in the, although we do suggest it's quite hard to conceive how if the heritage harm is outweighed by the public benefits, it's quite hard to see how heritage harm and the tilted balance could actually go the other way.
I think there's nothing in policy that says that it's impossible.
It's not impossible, but hard to conceive. But yes, no, you're right. That's clumsy language on my part.
So may I ask through you, is there a typo? My microphone's working.
Sorry.
Is there a typo in paragraph 74? There's a reference to, it may be that it's not and I've missed something impossible, but there's a reference to substantial harm.
Oh, that is, yes. Thank you. Yes. Yes. Thank you.
So the
I think
other,
I said less than substantial harm, but
in terms of the
yes, yeah, you're absolutely right. Thank you.
so the other point, I'm not obviously seeking to go back on anything Mr. Banner just said, but
No.
Factually, could you please note that Dr. Hickey did not author the statement of case? He wasn't actually asked about it. So
No. Oh, sure. We know that. Yeah.
Yes, he was.
No, thank you, Mr. Sargent. Mr. Banner, thank you very much.
Thank you.
We are decidedly approaching the end of the inquiry. Let me just ask the question, as I do formally at this point, whether there are any other applications that either party wish to make.
There are not.
No, sir.
Thank you very much indeed. Let me then just finish with just a round of thanks to everyone who's been involved in the inquiry. At this point, if you could reflect back my thanks to the councillors who turned up on Tuesday and then at other days to the inquiry. I do appreciate the contribution of local people. Mr. Khan is in that mix as well. I do appreciate the contribution of local people in the inquiry, and it's very well put when they came.
Thank you very much for giving us the opportunity.
I will just dwell on one fact that I have learned here is that my opening now needs to refer not just to mobile phones, but to Apple iPhones
Yes.
as well. Successful interruptions.
That was possible.
Nor did I.
So that's a little change to my opening statement.
They had to mute them, mind you.
If there are no other issues either party needs to raise, it's my pleasure then to formally close the inquiry.
Thank you, sir. Thank you for holding the inquiry. Establish one, because I don't have a
How'd you come?